The Caribbean Court of Justice, Appellate Jurisdiction on appeal from the Court of Appeal of Guyana. Hearing of the appeal in the matter GYCV number 1 of 2025 between Satyanand Persaud, Taij Bahadur, and Dhavanie Persaud. Dhavanie Persaud, Administrator of the Estate of Shamsundar Persaud. The members of the hearing panel are the Honorable Mr. Justice Anderson, President and Presiding Judge, the Honorable Madam Justice Rajnath Lee, the Honorable Mr. Justice Jamadar, the Honorable Madam Justice Anoniwu, and the Honorable Mr. Justice Ibu Usuji. Counsel, you may now enter your appearances.
May it please your honors, I am Jamla Ali, Senior Counsel, and with Mr. Sanjeev Dattadin and Ms. Mohini Anagu, we appear for the appellants in this matter. Your honors, may I ask very briefly the court's permission to congratulate on behalf of my colleagues, the Honorable Mr. Justice Anderson on his ascendancy, on your ascendancy to the presidency, well deserved, and to congratulate the recent appointments of the Honorable Justice Chantel Onunairu. Please forgive me if I get the spelling, the pronunciations. The Honorable Justice Peter Jamadar and the Honorable Justice Ibu Osuji. Your honors, those were the 3 judges since this newly refurbished court and my first physical appearance at this court. I have had the pleasure of appearing at this court before the Honorable Madam Justice Rajnath Lee. I thank you very much for your indulgence.
Yeah, thank you very much, Counsel. I wondered whether you had in mind Justice Balkan, who was recently appointed, or are you thinking of my brother to my left, Justice Jamadar? Justice Jamadar has received many, many congratulations. For many years.
President, I'm always happy to receive more.
Therefore, the first opportunity I had at the seat of the court.
And as my brother has indicated, he has an insatiable appetite for more. Congratulations. So that is fine. And
it took a while. That's
yes.
how long it took for me to come back to these courts.
Wonderful.
Thank you. To this apex court.
Thank you, Ms. Ali. Thank you, ma'am. Thank you very much. For the respondent.
Good morning, Your Honors. If you please, it is indeed a pleasure to be back. Tim Jonas for the respondent.
Thank you, sir. Are there any preliminary matters for us to attend to, or is the appellant prepared to proceed? The appellants, I should say. No preliminary matters? Well, please, counsel for the appellants.
Thank you very much, Your Honors. Your Honors, if you allow me briefly to congratulate the President of the Court. I know he's been to our beautiful country and he's felt love, so congratulations personally. Your Honors, the appeal in this court stems essentially, if we take the short version, from proceedings which were filed on the 16th of May, 2022 by the respondents against the appellants. That was High Court Action number 148, Statement SOC of 2022, and that could be found at page 427 of the record before you. What happened thereafter, Your Honors, was the appellants in this matter, who were defendants in the High Court, in that High Court action, they each filed defenses to that claim. The defenses are at page 446 for the first appellant and 454 for the second appellant. Briefly, or in summary, the subject matter of the claim filed was that the appellants in this matter, who were the defendants in the court below, had breached fiduciary duties owed to the respondent in these proceedings as a beneficiary of the estate of one Shamsundar. The respondent in these proceedings is a daughter of Shamsundar. However, for it to make some sense, Your Honors, it would be useful if we just go back just a little. The appellants in this matter are brothers of Shamsundar. They had, and it is not disputed, that there was an agreement or a document intituled promissory note, and whether it was a promissory note or whether it was simply evidence in writing of a debt, whichever it was, it is not disputed that that document existed and was executed on the 27th of June, 2010. And that was between the first appellant in these proceedings and Shamsundar, his brother, for a sum of money of $400,000. In principle, that was it. There was a second part to that, that if it was not paid, that certain property would be conveyed. Shamsundar died on the 1st of June, 2018, and the debt had not been paid. There was, in the chronology, an assignment agreement which was executed between the two of the sons of Shamsundar. And for convenience, I've referred to them in my submission as the two boys, and if I could continue so that it would be uniform. Those two boys were each, and it's not disputed, sons of Shamsundar. They, at that stage, executed an agreement intituled an assignment and an assumption agreement in favor of the first appellant. That was done on the 9th of April, 2019. Shortly thereafter,
Counsel,
there was, sorry?
on that point, was that document signed by the two sons, was it prompted by your client, or was it something that the two sons came up with on their own?
Well, the present, as I am instructed, they did that where they were in the United States, and that's where they reside. And you can see that the document was executed at the consular office, the intention being, or it appears, the mistaken belief being that they could have done that, and thereafter, the first appellant in this matter, Mr. Satyanand Persaud, would have been able to apply as their representative.
My question was whether the two sons set up that document, whether the two sons instituted that document on their own, or did Mr. Satyanand Persaud play any role in the creation of that document?
That document originated with the two sons. Now, in Guyana, the only way that anything can happen in terms of the probate proceedings, an agreement or any such agreement would be insufficient in going to a court, if you were to go to a court to apply, and a power of attorney was required. And a power of attorney was done subsequently the 1st of June. Now, that power of attorney was to represent the two boys by Mr. Satyanand Persaud, the first appellant. And he had in that power the ability to apply on their behalf for letters of administration to Shamsundar's estate. He never exercised that power. At no time did he ever exercise the power given to him. He, in fact, substituted Shamsundar's other brother, who is also his brother, who is the second appellant in this matter, to take on the representation of the two boys and to represent them, if necessary, in applying for letters of administration of Shamsundar's estate.
Mr. Data, didn't that power to substitute, that was in the original power of attorney?
Yes.
And is that something, as a long-standing counsel in Guyana, you have seen before?
Yes, indeed.
In circumstances like these, with a power of attorney to the attorney, and in that power of attorney, a power to substitute someone else?
Yes, yes, Your Honor. Now, Your Honor, when that substitution took place, Satyanand Persaud sought leave of the court to have the two boys appointed representative of the estate because he wanted to recover monies due and owing to him. That was before Madam Justice Corbin Lincoln, in the High Court. Despite the fact that the second appellant would have had a power of attorney to act for those two boys, the court required that they be specifically informed that this was being sought. Now, the two boys, they had to prove service to the address of the two boys and by FedEx delivery, and that was established. So the two boys were represented by the second appellant.
Could I ask, please, about the period of time between the power of attorney,
Yes.
Appointing
The 1st of June 2019,
1st of June,
and the substitution was executed on the 10th of June 2019.
so not a very long period of time, about 9 days or so?
Yes, a very short period of time.
Okay. In that time, what would have been the relationship between the first appellant and the estate?
Your Honor, unless he exercised a duty of any kind in relation to the power granted to him or given to him, there would have been nothing at that time. If he had taken a step in relation to the estate at that stage, then there would have been considerations as to what he would have owed to that estate. He did not.
Are you saying he stood in a fiduciary relationship with the estate during those 9 days? Would you accept that that is the case?
Your Honor, in those 10 days, whether he owed any duties to the estate,
Yes.
Your Honor, he owed duties to the boys, who were the people who appointed him. And he had the permission of the boys to apply for letters of administration. So the duty remained to who he was the agent of, until he took a step in relation to the estate. There could have been no agency at that stage.
The powers of the first appellant in relation to the estate, once he had been appointed with this power of attorney.
Once the substitution took place?
No, before the substitution. Once the power of attorney had named your first appellant, what were the powers possessed by this person in relation to the estate? Can you just be clear for me on that?
Well, Your Honor, his duty at that stage would be to those who appointed him.
Right.
And his duty at that stage would be to the principals, who were the two boys.
Right.
Until he did anything. So, Your Honor, if I may explain it this way. If someone gives you the power to do anything on their behalf, and you choose not to do anything as you are empowered to do, there could be no obligation or duty that is imposed by you unless in some form or fashion there are specific areas that would relate to health, safety, and matters like that, Your Honor. But ordinarily, a power of attorney can give you the power to receive service of documents, for example, or to inspect documents, or to do any of those things, and you could choose to say you don't want to do that. And that is why, at that point, from the period of the 1st of June, Satyanand Persaud did not want to do anything in relation to the estate and divested himself of that power.
But, counsel, wouldn't it be simpler in that kind of scenario for Mr. Satyanand Persaud, the attorney in fact, nominated attorney in fact, to have declined the nomination entirely? To say, look, I don't want to be part of this. I have a claim against this estate. Do not name me an attorney. I'm declining to accept the power of attorney, so it leaves me free to proceed with my claim against the estate. Why put one foot in and one foot out?
Your Honor, my instructions in relation to that, simple answer is, and that is, of course, an obvious consideration, but most citizens listen to lawyers, and the lawyer says, well, okay, you just need to have someone substitute to act for you, and you're no longer acting, and you proceed.
Somebody might view that as trying to have your cake and eat it too. Correct me if that's a different, going too far in that hypothesis.
Your Honor, respectfully, and I believe that it is that overarching position that excited the courts below. But if the courts had permitted a trial, for example, it would have been made clear that the two boys, as was pleaded by the second defendant who was acting on their behalf and who was the one that appeared and consented to judgment, acted on their instructions. But those two boys have never been named in the proceedings. But in the defense, which is paragraph 15 of the defense, Your Honor, of Your Honor, paragraph 15, which is at page 458 of the record, the second defendant, in his defense to the claim for breach of fiduciary duties, said he acted on the instructions of the two boys. He made it very clear that he was doing that. Your Honor, at that stage, the representative of the estate has been notified. The court required that. They have instructed the person who holds the power of attorney at that time to do what they do. But if you're alleging fraud, and if you're alleging the breach of the fiduciary duties, one wonders why weren't the two boys named as parties? It was clear that the transactions that resulted and came about came from them. But they have made no complaint in these proceedings, nor have they had a say. But the defense was of the second defendant, which he would, given an opportunity, have to prove by providing evidence in a court. Presumably, the simple way to do that would be that the boys would come and give evidence, or he would produce the documentary correspondence he has with the boys that he was authorized to do that. But no opportunity was afforded.
So, Dr. Den, I rather suspect you're taking a very long run-up to the crease, because I gather we're here to consider the decision of the Court of Appeal and whether it was correct or not. You're giving us background, if I may ask you. Right, so we want eventually for you to get to the point where we consider the merits of the decision, and we are willing to allow you some run-up. But I don't want to delay too long on this preliminary point, because I think we need to get to the point we need to decide.
Well, sorry.
Before you move on to that point, though, what did you just spend time with the judgment, the order that the Judge Corbin gave with respect to the administrator ad litem? Because it would appear from what I have read that the judge knew that that order was being made, so the first appellant could sue the estate, is that right? And for the sum that he eventually sued the estate for, is that right? In other words, everything was disclosed. I just want to get an answer on that.
Your Honor, I'm trying to remember the instructions I received, when to press and when not to press in front of me. But Your Honor, the old way was so dinosaurs. Your Honor, yes, because it was disclosed fully why and the amount and what it was, and the judge decided in those proceedings, informed them, and have them be formally informed, and then they take the proceedings forward. Your Honor, as it relates to the decision, if I may.
I'm not necessarily saying you have to jump immediately there. I'm just saying,
Okay.
We need to progress.
Well, Your Honor, a little bit, it is worthwhile, Your Honor, if I may, just a little bit, about...
Mr. Dati, let me just understand. You're still on the High Court?
Yes,
So
just...
the High Court decided this on the limitation point. Is that right?
Well, not
I'm just trying to understand. You're on the fraud point. Yeah. What's the point you want to make about the fraud point?
Your Honor, what I wanted to address before I get to the limitation, to deal with it separately, Your Honor, is the issue about this thing of the court saying, we want you, or we're taking the approach that there is no defense raised. Now, in the submissions that were made in that court, and if we call them all together the abbreviated disposal, not to use the word summary, because that would create some confusion, but the abbreviated disposal of the proceedings, Your Honor, there were two things that were at play. There was firstly the possibility that what it was is striking out the defense under Part 14 of the Civil Procedure Rules, which 14.01A provides for striking out where the pleading does not disclose a reasonable ground for defending the claim. Now, if 14 was employed, then 14.03(1) would have to be applied, which means after you have struck out the defense, then you have to make an application for default judgment pursuant to Part 12. And that is expressly contained in the Civil Procedure Rules. You have yours? So if, as it was, that it would be striking out, the consideration, Your Honor, is does not disclose any reasonable ground. The actual words of it is does not disclose any reasonable ground for bringing or defending. In this case, it would obviously be no reasonable ground for defending the proceedings. If it is under the summary judgment procedure, which is Part 15,
It's in focus. I don't know if we can get some assistance. The rules that you have put up on the screen, no, yes, I don't know how you focus the.
There must be a button there.
oh, there's a button.
The project, the overhead has to come into focus.
Is that better, Your Honor?
When it's bigger, yeah, now it's coming to focus now, yeah. You can make it a little smaller so we can read all of it, please. Yeah.
1401. No, we got it. 1401A. Sorry, Your Honor, which says, in addition to any power, etc., it goes on. The statement of case, and in our CPR, as in most, statement of case means both the claim form and the defense, does not disclose any reasonable ground for bringing or defending the action, A1, Roman numeral I. So if that was done, Your Honor, with your permission, if I could just show the court 03, which is the bottom. 14031, where a defendant's statement of case is ordered struck out, the claimant may make an application under Part 12 for default judgment. So if indeed the court was striking out the defense, then the consideration was it doesn't disclose a defense, which incidentally is more along the language used by the High Court judge. And for judgment to then happen, they would have had to be in the second part, which is to apply for default judgment once the defense had been struck out. Your Honor, if it were summary judgment, which comes under a different provision, Part 15, we solved it. Part 15, which is 1502(3)(b), Part 1502(3)(b, and they say that for that one, if it's summary judgment, that the defendant has no reasonable prospect of successfully defending the claim. So the language is slightly different. Now, Your Honors, respectfully, it involves both of these matters essentially end the same way, if I may speak of it loosely. If you're struck out or if summary judgment is granted, the case would end against you. Essentially, that would be. But in the consideration, especially as it relates to summary judgment, as with the other considerations that relate to striking out, the learning or the cases suggest that the court should not be too quick to pull the trigger on either of those situations. And while it is said that the court should not allow proceedings to proceed that have no prospect, if there is some, and it's not fanciful or frivolous, and this is a defendant, then, Your Honors, respectfully, what would arise, or what can arise, is the court is allowed to case manage the proceedings, meaning take it forward, as far even in some cases as mentioned as putting in the witness statements, because what is being pleaded. And at the stage of case management, there would still be a power that the court would have to say we don't find that it is disclosed. I'm not saying, Your Honor, that means that's what it is, or I'm suggesting in here, but there are powers of case management that would allow you in these proceedings, Your Honor, the assertions of fiduciary say the duties are owed to the estate, and they were appointed to the estate. With great respect, Your Honor, it is not disputed, and there is no doubt that before you act, even if you have a power of attorney for an estate, before you act on behalf of the estate, you need the intervention of a court. The probate registry.
My brother, Mr. Chairman, I'm a little bit dislocated, I must say. What is it that you're speaking to at the moment? Decision of the High Court?
Yes, Your Honor.
Right.
Yes, Your Honor.
But we are not being asked to review that decision, are we?
Well, Your Honor, the High Court decision is upheld by the full court,
Okay,
upheld by the Court of Appeal.
correct.
Now, Your Honor, the reasons as to what took place really only is contained substantially in the judgment of the High Court. The other courts or the other courts agreeing and saying that it is, does not give a reasoned position. It says that in the full court, for example, it was said they've read the decision and they have no reason to disturb it, except for one other issue on Williamson and Ryder.
No, I understand you perfectly, but the point remains that at our level, we are not looking to review, as far as I understand it, the decision of the High Court.
Indeed.
What I think you have asked us to do is to review the decision of the Court of Appeal.
Yes, Your Honor.
And I'm still waiting for you to get to that decision.
If I may.
To indicate to us why it is you say that the Court of Appeal erred in its decision.
Well, the refusal, the proceedings at the Court of Appeal came from the full court. The Court of Appeal refused to consider and move forward. So when I say consider and move forward, they failed to consider the merits of the case which was before it, and they failed to consider whether, in the circumstances, there was a miscarriage of justice.
Why did they fail to consider those things?
Your Honor, on the one hand, it was an issue of the proceedings that were brought to the court, the application for leave was filed out of time. And in the second, it was they saw no reason to disturb the findings of the court below.
Right, so do we have that decision of the Court of Appeal that you could display for us?
Your Honor, we don't have the reasons for the decision.
Was there not an order? Or the transcript, yes.
No, neither is there, as far as I read the order. What we do have is a printed,
Transcript.
yes, please.
Okay, so could you take us to the point in the transcript where you say that those two
One moment.
decisions were made? Yes.
Can you bring up the Court of Appeal for me?
Mr. Dadadin, while you look for that, or while your colleagues help you look for that, I'm looking at your notice of appeal,
Yes, please, Your Honor.
and we see paragraph 2, ground of appeal. Paragraph 2, clause 1, clause 2, clause 3, all deal with what? I think that's the point we might be getting to, isn't it? That the Court of Appeal would not grant extension of time. Is that why we're here or not?
That is part of the process, Your Honor. Now,
of the record. So I'm informed.
yes, Your Honor, that is true. And that order simply says that the motion be and is hereby struck out.
Thank you.
Your Honor, under the Court of Appeal rules themselves, the court has a power under Court of Appeal rules to extend.
Mr. Datin, I'm just, I'm maybe a little tired this morning, but I'm honestly just a little bit unclear. So just frame this for me. Are you now going to come to the error in the Court of Appeal in its failure to apply its discretion to extend time under the Court of Appeal rules? Is that where we are now in your submission? Is that what we're on now?
Yes, please, Your Honor.
All right, okay, good, thank you.
And with respect, I suspect that's where you should have started. But nonetheless, please.
Your Honor, if I may, well, let me answer first, and that would be and then I can address the court. Your Honor, Order 2, Rule 2 provides the time for making the application, and it was made out of time. It is recognized under Order 1, Rule 8 of the Court of Appeal rules. In the interest of justice is the phrase used.
Are you able to put up the rules for us? If you're not, we can find it.
Court, we'll put it up shortly on the screen, Your Honor.
By how much were you out of time?
Pardon me, Your Honor?
By how much were you out of time on your computation? By how much? How long were you out of time?
Your Honor, the period was 14 days, and I think we filed 43 or 44 days
So
beyond.
you'd say, would you agree about a month?
A month?
About a month. That's agreed, yeah? So you're a month, this is a case in which you're about a month out of time.
My friend says he agrees with a month.
Very good, right, so that's where you.
Approximately.
And did you request an application for
Well,
leave
Your
filed
Honor,
out of time?
Your Honor, in relation to that, we did make an oral application. We do have a transcript. We don't have anything about that on the transcript. And there are parts which are inaudible or which are listed on as inaudible. And Your Honor, I've spoken to my friend on the opposite side, and he had indicated at the leave stage what his position is. And I don't wish to preempt or to say, because he's here to speak for himself, but he says at the leave stage, Your Honor, he says he doesn't say it wasn't done. He didn't have a note, and my note was very brief, and I had indicated to the court what my note was at the time.
I'm trying to understand. Sorry, so there is no evidence in the transcript that
No.
you made an oral application?
No, Your Honor. When that issue arose, if you follow it, Your Honor, you will see that that's where it says inaudible.
Yes. Oh, I see. May I ask, with your approval, Counsel, Mr. Jonas, do you concede, Mr. Jonas, that there was, in fact, an oral application for leave that was made in the Court of Appeal?
Your Honor, I have difficulty there. I'll tell the court why. If Your Honor asks my subjective memory, you will not get an answer. I do not remember. If Your Honor asks my objective view and recollection of what took place, I do remember that there was a discussion whether my friend should withdraw or if it should be struck out. But in terms of an application for an extension of time, no, sir, and I'm sorry.
There's no need to be sorry, you're just relying on your recollection. Thank you, sir. Yes, Mr. Dartinen. So we have no evidence before us that there was an oral application for an extension of time. I think you'd have to concede that, would you?
Your Honor, I
Unless
don't.
you're willing to give evidence now, but then you'll be subjected to cross-examination, Mr. Jonas.
Mr. Dartinen, just a follow-up question. You may get to this, but I have to, because of what you've just indicated, jump to Order 2, Rule 3, Paragraph 4, actually Paragraph 5.
Of the Court of Appeal rules,
Of the
Your Honor?
Court of Appeal rules.
Yes, Your Honor.
And this is the provision that governs how an application for an extension of time should be made. Now, I'm asking this question because irrespective of whether something may have been said that wasn't captured in the transcript about seeking an extension of time, Order 2, Rule 3, Paragraph 5, as I read it, speaks to the fact that the application for enlargement of time must be made by summons, and when made to the court shall be made by motion. And it says that that application has to be supported by an affidavit.
Yes, Your Honor.
So even if an oral application had been made, was any kind of affidavit before the court for consideration that would have set out the good and substantial reasons for the extension of time?
Your Honor, if I may respectfully answer you this way, that relates to the filing of a notice of appeal. So that is if your notice of appeal is out of time. If the application for leave is not an appeal, it's a motion is filed to the court to seek leave from the court to be able to file a notice of appeal. So this is a step. There are some applications. There are some matters from the Court of Appeal, from the full court appeals, which require leave of the Court of Appeal. So this was not an appeal. This was a motion to seek leave to appeal. So I agree with Your Honor that this does say that an application for an extension of time is required to be made by a motion and an affidavit. But respectfully, Your Honor, this applies to the filing of a notice of appeal and not an application for leave to appeal.
But Mr. Dutherton, even then, there are rules of court, and the rules of court set out at the minimum rules of efficiency about how things must be done. Where a party falls short of those rules, there is an obligation to explain to the court why non-compliance occurred.
Your
One
Honor,
second, let me finish. And in that explanation, it is expected that counsel would put their reputation, their professional integrity, or whatever you may call it, on the line. And the best way to do that would be an affidavit to say, this is what happened, this is why we were unable to comply. Isn't that how this thing should work? Is it enough for counsel to say, well, we're out of time, judge, grant us leave to extend, and leave it at that?
Your Honor, so the practice, because the Court of Appeal in Guyana still has the old rules that exist pre-CPR. The CPR in Guyana only applies to the High Court. And under the old rules, even the old rules that were existing in the High Court, the requirement that every matter is met with an application in writing to the court is not the practice as exists in the Court of Appeal. And oral applications being made to the court is for leave to file documents, for leave to extend the time in which documents are filed. It's not usually done by, as in the courts below, where an application and an affidavit in support is filed. That is not usually the practice. It is still the old system where you would ask for leave.
Mr. Dutherton, in answer to my sister, thank you, President. In answer to my sister about Order 2, Rule 3, and Sub 5, you said that Sub 5 applies only to notices of appeal. With respect to Order 2, Rule 2.1, which refers to an appeal that lies by leave only, and I take it that is where you're at.
Yes,
What
Your
is the
Honor.
relevant rule for enlargement of time, please, if you could assist us?
So the part that relates to extension of time where it's the leave position, Your Honor, respectfully, I think 1.8, which is the overarching provision of the Court of Appeal rules to permit the extension of time in exceptional circumstances, which applies to every extension of time, is the applicable rule in these circumstances.
Do we have that on screen?
1.8, Your Honor.
Yeah, I'm hoping our registry would put it up for us. But once that is done, yes.
That's it, Your Honor, sorry. The enlargement in time and departure from the rules, which is an overarching provision.
Requirement in the interest of justice.
Yes, please, Your Honor.
So where are we now? We are at a place where you have, is it a decision of the full court against you?
Yes, Your Honor.
You wish to apply, you wish to apply for leave
Yes, Your Honor.
to appeal that to the Court of Appeal. You have 14 days in which to make that application.
Yes, Your Honor.
You have not done that.
We're out of time, yes,
You're
Your
out
Honor.
of time. And you come to the Court of Appeal, and the Court of Appeal points out that you are out of time, and therefore you can't proceed. In fact, they invite you to withdraw whatever application you were making for an enlargement of time. Now, why would you say that the Court of Appeal was wrong in coming to that decision? Because you're clearly out of time. You have not made any application for an enlargement of time within which to lodge your application. Why would the Court of Appeal be wrong in coming to this individual?
Your Honor, the overarching provision is in the interest of justice.
Right.
The application that was before the court demonstrates in very, very clear terms that the courts below engaged or conflated two issues, being the representative of a estate and being the representative of persons who are beneficiaries of that estate. And what has happened is two other judgments of the court below, which were made for the judgment and for the appointment, for which no leave was sought in those proceedings to join. What happened is it came to the time of execution, but Mr. Satyanand Persaud, who is the first appellant, he demonstrated in all of those courts his defenses, and he dutifully did it. And in the final court in his application, so the application was filed out of time. But the court had before it, and this court has said in Campton Orion that Mohan, I always say it wrong, it's Mohan, I think, and Gupraj Persaud, in 2012, that in considering whether to enlarge time or to not do so, the court should have regard to the merits, and the court should have regard to the interests of justice, which is enshrined in our rules as it is enshrined in this court, that if there is a miscarriage of justice.
Case, was there an application made for an enlargement of time?
Your Honor, it had not been made in the first instance that it was done. So I think Sankar, no, Your Honor, yes. In Sankar,
Yes.
with GRDB, it was not made in the first or even, I believe, the second time. Because what had happened is it was filed incorrectly, then it was filed out of time, and then they came back and filed a third time and corrected all of that and asked. So the first two times it was not done.
And that filing was made where? In the Court of Appeal?
Your Honor, in Sankar,
Yes.
yes.
That's the problem, but there was no application made in this case for an enlargement of time.
Mr. Datanin, I have to return to this. I just want you to please return to Order 2,
Yes, please, Your Honor.
Rule 3. Could you confirm, we all agree that there was a time limit of filing of 14 days from the date of judgment, is that correct?
Yes, Your Honor.
Where is the rule that prescribes that time limit?
Your Honor, I think it's 2-5. 1 second, Your Honor. Sorry, Your Honor, Section 6(4) of the Court of Appeal Act. Sorry, Your Honor, are you asking where it says that leave is required or where it is stated the time?
Yes,
The latter, the time?
the time frame and that leave is required.
Leave is required is at Section 6(4) of the Act itself. And the rule that prescribes the time for making the application to be 14 days is Order 2, Rule 2(1).
Right, thank you.
So the Act is the part, and then the rules have the time period.
And you agree that the general power of enlargement in Rule 1.8 applies to that?
Yeah, that is the only provision, respectfully, Your Honor, that would apply. And it would be in the interest of justice.
Yes, indeed. And who considers whether it is in the interest of justice?
The court, Your Honor. The Court of Appeal.
Court of Appeal, yes. But there's nothing before them. There's no application for an enlargement of time for them to consider whether it's in the interest of justice to approve an enlargement of time.
Your Honor, that is indeed a difficult position, Your Honor, because as I had indicated to the court at the leave stage, that was. The transcript, I thought, would be very clear and no doubt about it. The transcript is marked as inaudible at parts, and that's where we're at.
But let's just drill down. Take us to because this may be significant in the case, take us to the point in the transcript where you say this arose and it is inaudible. Yes. Because the context around, let's see what the discussion was about. Because if it is inaudible, it is possible that it could have been there, but not recorded. That's fair enough. Mr. Jonas says he cannot recall and would not want to venture beyond that, which is respected. What were you all discussing? At what point? When do you recall, having looked at the transcript, when do you recall making this audible application? Is it that his submissions are that we are out of time? You see that there?
Yes, Your Honor.
Yes, Your Honor. The Chancellor, application for what? You're filing an application for extension of time. So clearly, at line 8, the court is asking you about an application, correct?
Yes, sir.
And inquiring whether what you're talking about is filing an application for time. Your response is no. No, please, Your Honor. That's what you say. Yes. What I'm saying is I've received senior counsel's submissions. His submissions are that we are out of time. Chancellor makes a comment. You then go, a little bit is inaudible, but it's not the end of the thing. No, now. My only application today, Your Honor, was if the court would permit me to amend the applications before me or to file a separate application as it relates to the period of time. You need to translate some of this for me. No, Mr. Jonas, sorry. No, Mr. Datidine, you move this court. And then we are going along. So when I look at this, the question in my mind is, can you and Mr. Jonas, your opportunity will come. What was this about? Is this where, what perplexes me is the court is raising with you directly about filing an extension of time, right? Your response is no. What I'm saying is I've received some, now we know Mr. Jonas said this on a few occasions, that you're out of time, I think in different instances, but we know that. So that has some context. You say it. His submissions are we are out of time. Well, help us.
Your Honor, Your Honor, what is the position is, from when I looked at the notes, I thought it was when I was going at the part that is, we can't go back and predate, which is why I asked if it would be mindful to amend, because that would be the only thing that I could think of. And that was in relation to asking for the motion itself to be amended to include a prayer for an application that it be granted out of time. And above that, where I said that I can't go back.
Is the screen in sync with you? Is what's on the screen? You're saying something. Is your associate in sync with what you're reading from?
I'm reading from the
I know,
notes,
but
yes.
we are being shown something.
Oh, Sorry.
Is that in sync with what you're showing us? Just let's make sure we're on the same page, literally.
.337, Your Honor, if I may. At the top of 337, and that was in relation to the discussion to ask for leave, because what it would be is in the motion that is filed out of time, the first prayer is usually the application for,
Is it that this line, and for an application for leave to be heard out of time? Yes. Is that where you're saying we can find evidence that in your dialogue before the Court of Appeal, you
That-
were asking to amend your substantive motion, which was earlier, to include this, a relief, a limb of relief to be heard out of time?
yes, Your Honor.
And i.e., that constituted your oral application shown in the evidence in the transcript for, in your words, to amend the motion to include the application of out of time.
Yes, Your Honor, that's why we were seeking to amend.
And that's how we must read the transcript and make sense of it.
Respectfully, Your Honor, yes.
All right?
But there's an earlier reference to the amendment of the application in the transcript. I'm looking at page 584 of the Record of Appeal. I'm not sure it corresponds with what's on the screen. But there is an exchange before we get to the exchange on the screen that concerns the application to amend the existing application for leave to appeal. As I said, it's page 584, I believe I'm looking at, of the Record of Appeal. And actually, it starts at page 583. I hope my numbering is correct. So on page 583 of the Record of Appeal, and I believe it starts at line 22. Is it 583? This is recording you speaking, Mr. Dattadin.
Yes, Your Honor.
And you say, I received the submissions of senior counsel, and my only application to the court today, or hopeful application to the court today, was to apply for leave for the extension of time.
Yes, Your Honor.
On the next page, starting around line 10, you say, this is after there is a recording of inaudible or incoherent speech. Now, my only application today, Your Honor, was if the court would permit me to amend the application that is before me, or to file a separate application as it relates to the period of time. On page 580, oh my dear, is it the correct page? On my screen, it's blurred. You say, we're not aware of that there was a limit on it. We thought it was 6 weeks as it was for appeals. The court then goes on to speak to its willingness to hear you on the matter, given what was before it, which was
Yes.
an application for leave to appeal from the decision of the full court.
Yes, Your Honor.
So I am trying to understand, even if we take into account any parts of the transcript recording inaudible speech, what we are to extract from the exchange would have been your submission to the court about seeking an extension of time for filing the application for leave to appeal, the substance of it. Not the fact of a desire to do so, but the substantive basis for seeking to do so. Because what I'm able to extract from the transcript is a desire that you are registering at the date of the hearing to seek an extension of time. There was a recognition from the submissions that were made by Mr. Jonas, and I believe Mr. Justice Jamadar also referred to other documents that would have been filed. I think, an affidavit in response that would have pointed to the filing of the application out of time. And I believe the first filing was as early as May of 2024. And then in the substantive submissions that the respondent made, the point would have been made again. But at the date of the hearing, what I am able to pick up from the transcript is you registering, I believe for the first time, based on the submissions that were made, a desire for the court to permit you to make an application for an extension of time. But I'm not able to discern from the record any reasons you would have put forward for that extension or wanting that extension, other than the reference to you believed it was 6 weeks, and the submissions would have indicated it, the application for leave would have needed to be made within 14 days. Is there anything else you can point us to from the transcript that would have evidenced any reasons you would have put forward for the application?
No, Your Honor.
Counsel, you referred us to Order 2, Rule 2.1
Yes, Your Honor.
as the basis for leave
Yes, Your Honor.
to appeal. Okay. Keeping that in mind, now, earlier in your remarks, you sought to make, sorry, before I go there, you also, in the transcripts we've seen in the Court of Appeal, you thought you were operating on the basis of 6 weeks.
That's the time for filing a notice of appeal.
Why did you think 6 weeks operated in that case instead of
Your Honor,
instead of 2?
Your Honor, the time for filing an appeal proper from the High Court to the Court of Appeal is 6 weeks. And I thought I was mistaken.
Are there cases where you do not need leave, where there's appeal as of right?
In matter, yeah, as of right, that would be the best way.
What is the time limit for that?
6 weeks.
6 weeks. So where you have a right of appeal as opposed to seeking leave to appeal.
Yes.
All right. Earlier you spoke of, you were careful to make a distinction between abbreviated procedure, which you said that was what happened before the High Court judge, the Chief Justice.
Yes, sir.
And you said not to confuse that with summary procedure. Why did you draw that distinction?
Your Honor, I only said that because summary judgment and the whole process of summary judgment and a summary procedure, I had been in this court, I believe, in the Nizamuddin matter, where the whole issue of summary and what is the meaning of summary and Your Honor, because it is I don't want to say a term of art, but because it has a specific meaning in civil procedure rules and as this court had ruled, I didn't want to say that and then connote that I was trying to say that, because I was really speaking of two separate things. One is summary judgment, one was striking out. Both of which are in fact procedures to abbreviate.
Abbreviated procedure, fair enough. So when you say what the High Court judge did was an abbreviated procedure,
Yes, Your Honor.
what were you getting at, please?
Your Honor, the claim was filed, the defenses was filed, the defenses displayed and demonstrated that there was a defense to the claim, and the court took the view there was no defense. Without hearing evidence or without investigating further, we respectfully believe that that occurred because the issues were conflated, representing the two boys as their power of attorney versus being a representative of the estate. The judge and the full court and the high court judges both said that the first appellant was a representative of the estate. He has never been a representative of the estate. In fact, Your Honor, to make the point, the high court ruling of Justice George at page 460 of the record says that the issue was the first defendant was a representative of the brothers to administer the estate, and he got them appointed so he could sue the same estate. That he wasn't appointed to represent the estate. He was appointed to apply, and if a court saw fit, to grant him those powers.
Were you thinking the High Court, the Chief Justice was in effect conducting an ultimate, basically engaging in an ultimate disposition of the case without going through a trial?
Yes, Your Honor.
And that's different from a summary procedure.
Well, Your Honor, it would depend on which rule. Was it Part 14 or Part 15? But Your Honor, we had submitted two authorities as it relates to that. One was the Swan and Hillman position, and then a few days ago we found a very useful Trinidadian case of, that's not reported, Trinidad, UTT and Julian, that examines the whole position that these two things are usually rolled into one, the two positions, but at no stage does it entitle the court to embark on a mini trial or to make findings without there being clear evidence that this does not apply or work.
So you were operating under the hypothesis, perhaps, that the Chief Justice conducted a mini trial of the case.
Yes, indeed, Your Honor, and the Chief Justice relies on the affidavit evidence provided by the claimant, who are the respondents, because they made an ex parte application to the court to obtain certain orders in relation to staying other judgments. The appellants in this matter had no ability to respond to the ex parte. It was heard and determined ex parte.
So that the findings of the Chief Justice, assuming she was correct, would have been binding on both parties and would have disposed of the case.
Yes, Your Honor.
If that's the case, Mr. Dutherton, why did you seek leave to appeal rather than say, well, the Chief Justice appears to have ultimately disposed of this case, I have a right of appeal?
Your Honor, the same Nizamuddin case says that if a matter is determined summarily, the appeal lies to the full court. In Nizamuddin, in the exact identical situation, Your Honor, I had appealed to the Court of Appeal. And Your Honor, Justice Jamadar told me I was in the wrong court. So
now, last question on that
I could have been
train.
wrong, right? I could have been wrong. This court may decide that I was wrong in doing that. And I'm happy to be wrong in that regard.
Your Honor,
But that's why you did it. That's why you
That's
did
why I
it.
did. But
Even
if I could
was
only say
wrong,
one
that's why
thing,
you
Your
did it.
Honor, if I could only say one thing about that. As a result of that decision, I've been in practice since the previous century. The full court has never had so many appeals. The appeals went to the Court of Appeal. And these summary matters and all these FDAs that are being filed and whatever, all of the appeals are now parking in the full court. And I don't think the full court was quite designed for that. But Your Honor, be that as it may, that's a matter that they need to amend rules or make them clearer for that position. But
If I may complete that line of questioning I was on, assuming even that you might have, by some theory, argued that you had a right of appeal as opposed to leave to appeal, you would still have been out of time. Is that correct? Even on the basis of the right of appeal, you would have been out of time. I'm asking you.
Your Honor, at the time that I filed it, I thought it was within time. Your Honor, as my friend said, I am thinking, I've thought, because 30 days plus 14 would take you beyond 42. So it might have been a situation where that was done out of time.
Pardon me, sorry?
It may have been a situation where that was out of time.
You might have still have been out of time.
Yes, Your
even on the theory of 6 weeks.
Yes.
Thank you.
Chair, can I just, Mr. Dattadine, just to bring this back to this appeal from the Court of Appeal. Is it, I'm just trying to pull this together to try and see if I am understanding where this can go. Are you therefore saying that the Court of Appeal erred in not granting you an opportunity to make a full application for an extension of time because in the interest of justice, that's where you are, correct? In the interest of justice, and given what transpired below, which we have rehearsed, it amounts to a miscarriage of justice.
Yes, Your Honor.
Okay.
And that is our submission in this court.
Right, so that is why we should review the discretion of the Court of Appeal not to consider giving you an opportunity to make an application to extend, et cetera, et cetera, et cetera.
Yes, Your Honor.
Right, okay, good. I understand what you're saying.
How could you have made that application for an enlargement of time?
In which situation? In this situation, Your Honor?
In the Court of Appeal, yes. I presume you could have made a written application?
Your Honor, it could have been written, it could have been oral. In matters that have been dealt with, in which you make oral applications to the court, they would usually, because there is no requirement, as in the court below, that everything be in writing, that you would advance what your reasons are, and you would say, and if they say that it's to be written when they've heard what you've said, then you would reduce usually it would be submissions that you would be putting, but not the substantial.
Two very small points, Mr. Dattadine. One is in relation to the transcript. Towards the end, I must say that my pages are numbered differently from the numbers I've been hearing. But towards the end, 17 of 20, there is a report of a statement that you made. This is coming towards the end of the proceeding, where you say, Your Honor, if I may indicate, if the court is permitting or the court is mindful to permit me to withdraw the application, then that would be the path we would take. But unless I'm mistaken, I'm not sure the court is permitting me to do that. If the court is permitting me, then that would be the position, of course, subject to what Mr. Jonas will say. Just to be clear, what application is it that you had in mind there?
Your Honor, as you could see, much of it was the court saying that I should withdraw the application, and I indicated very early that I had had no instructions that would allow me.
Which application is that, for leave or for the enlargement of time?
Your Honor, I have read it, and I see that on the reading of it, that it appears to speak, I'm withdrawing the application for the enlargement, the application for leave, Your Honor, but it was never, because as could be, that I said earlier, where the issue of leave to appeal was being, the court was suggesting that I withdraw it repeatedly, and I indicated I had no instructions to do so, and that never changed, that I had no instructions to withdraw. but the application to amend so that I can include it in the prayer. So hopefully, if I would withdraw that, then I would have stated orally what it was in full. But we didn't get that far. Yes, please, Your Honor, because it was going to be a very simple application that relates to Order 1, Rule 8, and that in the interest of justice, what took place in the courts below was a miscarriage of justice.
So you indicate here that you are willing to withdraw that application. That is the path that you will take.
Well, the application was as it relates to amending my
Yes,
motion.
yes.
So I was going to withdraw and then say what I have to say orally to the court instead of going the path of having to put it into the motion.
And then the other point I wanted to just clarify is one which came up obliquely in the Court of Appeal, which was the Chancellor's recognition of you as senior counsel.
I'm not, sir. I'm still
She
junior.
recognized you as being a senior in the profession or something to that effect. And we would agree with that we have the utmost regard for how you conduct yourself and your profession in the court. But having said that, you realize that there is decisions that we have taken, well, there are decisions we have taken, and I'm thinking particularly of Mitchell and Mitchell against Wilson, in which you have very, very clearly said that misunderstanding by counsel of the time limit for filing a notice of appeal is not considered a good reason for extending time limits. So there is that, and I think, quite frankly, you have made the point that you thought it was 6 weeks that you had, and in fact you had 2. So if there is a mistake on the part of counsel, we have said in the past that is not good enough reason for the extension of time. I just wanted to bring that to your attention without, of course, saying anything negative. In fact, I've tried to say something very positive about your performance in the court and outside. Thanks.
Your Honor, if I may say, I recognize and I respect the position of the court, but the Court of Appeal, in applying 1-8, there was a case, the decision is Geoff Haynes, and I don't readily remember it, but it was, in that case, it was the same thing. The counsel had counted incorrectly, and that was in the interest of justice. Your Honor, I appreciate that, but the Court of Appeal in Guyana decisions where the matter relates to that, specifically in the application of 1-8 in the interest of justice. And Your Honor, even when the court looked at Campton Orion, in that decision too, it was again a period out of time. In Sankar, in this court, it was again a period of time. And we followed the Harney and Regal's model in the Caribbean, which is essentially that justice and whether there's a miscarriage of justice and the demonstration of a miscarriage of justice and a grave error, or in this court they've sometimes said an egregious error of law in relation to the matter, is what allows you to get the discretion. If you argue in a fanciful case, if you are making a situation that is untenable, then, Your Honor, that would be so. But, Your Honor, this is a litigant who has, since 2019, he was given a power, he stepped out, he realized that it would put him in a position. He filed the first proceeding, he filed a second proceeding to appoint, he filed a third so that he could get his judgment. He was proceeding. Then proceedings are brought against him, which says he had fiduciary duties and fraud is not pleaded in the proceedings where the court found that he acted fraudulently. And he defended as he should. And then he appealed to the full court as the rule said he should. He did his submissions, so he missed one time.
Counsel, miscarriage of justice is a large concept. It's something that judges try very hard to avoid. But I do think you need to address us on that. Sometimes it can be more in the appearance than reality. Is it possible here? Let me rephrase that. Can you speak to the effect of what Chief Justice's judgment, the effect of the judgment of the Chief Justice, what was the effect of it? I'm thinking here, was it merely to set aside a consent judgment? Because you started there. This case had to do with that. There was a consent judgment issued by Mr. Justice Hananan. Is it possible that the miscarriage of justice we are talking about is simply setting aside that judgment so that we don't have a consent judgment, so that if there's a litigation on the matter, it might have been considered on the merits of whether $400,000 was owed or not? So what is the effect of the Chief Justice's judgment?
Mr. Dhavanie, I'm going to ask you to respond, but be very brief, please, because time has gone.
I will do my best, Your Honor. Simply put, Your Honor, it means that the agreement, which is intituled pro note or whatever, that evidence is a debt could not be enforced. The Chief Justice respectfully was also incorrect, which is the only last point I want to raise about the limitation period.
Oh, 1 second, please. I know you've been, this is very important. The evidence of debt could not be enforced. Is that all there is to it, or that the evidence of debt may need to be gone back to be looked at more critically through a trial?
No, Your Honor, so the limitation point, which is raised in this court and pleaded in the court below, does not arise. And we've put in our submissions why, but if I could just elaborate shortly. The agreement was 27 June 2010, to be paid by 27 June 2014. It was installments contained, but the agreement provided, and the agreement is at page 182 of the record, the agreement provided that if it was not paid in the 6-month installments, then he could charge interest. Didn't say he could claim the amount or the full amount became due. That would put it under Section 3 of our Limitation Act, where the limitation period is 6 years. 6 years from 2014, 27th of June 2014 is 27th of June 2020. The Limitation Act provides if there is no plaintiff or defendant for any reason, it is suspended, a common provision in the Caribbean. He died in 2018. A representative was not appointed until the boys were appointed in 2019. These proceedings were filed in 2019. The proceedings were filed within time. So the argument, the counter to that of what was provided to the court is that Section 6 of the Limitation Act applied.
Mr. Dhavanie, please stay with me.
Sorry, sir.
Sorry, I'm sorry, my brother. We are going to have to conclude your submissions. Was there any final thing you wish to urge upon us? Thank you.
Your Honor, I only wish to raise, in the vein of Order 1, Rule 8,
Yes.
which says that in the interest of justice, the application, the documents, all of this record, and that's why we presented the record in this court as we did in the court below, and there's so much repetition. We presented in the Court of Appeal everything, meaning the judgments below, the documents, the other proceedings, the orders of Justices Corbyn, Harnanan, the power of attorney. We presented everything that we had to that court. And this court, under the rules of the CCJ, and a miscarriage of justice, this court has the power to act.
Thank you. Thank you, Mr. Datterton.
Thank you, Your Honors.
Yes. Thank you. Thank you, Counsel. The court will rise for a few minutes. Thank you. Thank you. Court resumes, and I think we're now due to hear from the respondents through Mr. Jonas. Please, sir.
Thank you very much, Your Honors. Your Honors, there has been a smorgasbord of issues that have come up, and therefore, perhaps necessarily, there's a certain amount of scattershot in my approach. And if there has been any lack of clear direction, I take responsibility for it and apologize. But given the thrust of the discussion this morning, with your permission, I believe it is opposite for me to start where we ended, which is with the transcript that took place in the Court of Appeal. Is this better, Your Honor? Thank you very much. Yes, please. So with your permission, I'll start with the transcript of what took place in the Court of Appeal. And I will ask Your Honors to observe a number of dates in chronological order. The application for leave to appeal from the decision of the full court was filed on the 22nd February 2023. Now, we've discussed that it should have been done in 14 days, and it was done a bit over 4 weeks out of time. So no need to belabor that. What I would also like to point out is it wasn't served. So under the Court of Appeal rules, although no specific provision is set out for the time of service, it is generally contemplated for notices of appeal and documents filed under the rules that service be effected forthwith as quickly as possible. The respondent therefore belabored under the happy delusion that the full court had ruled and we were good to go. And in fact, it was not until sometime in May, I believe, that, so this is 6 months later, 6 months after the 2 weeks, after the 1 month, then 6 months, that the respondent learned an application had in fact been made for leave to appeal. And learned because a notice was sent from the Court of Appeal to counsel who was on record in the full court, me. So that's how we learned. And in a state of panic, because I thought I had been served and maybe missed it, we made our inquiries and discovered no, there had been no service. So we got the paperwork and we put in our affidavit in answer. And Your Honor's record at page 554 will reflect that the affidavit in answer was filed on the 22nd of May. Now that affidavit in answer was filed with the permission of the Court of Appeal because the notice which I received had fixed the date for hearing of the application for leave to appeal. So I appeared in court and said, we don't know about this. We're very sorry. We would like some time to respond. And that affidavit was filed, therefore, after the first hearing date fixed in the Court of Appeal for hearing of this notice of application for leave to appeal. Affidavit in answer filed 22nd of May, setting out that you're out of time, you have problems, you need to fix your house. And written submissions put in on the 18th of June, if Your Honors have regard to the transcript, page 397 of the record. Your Honors will see the reference by the Honorable Chancellor Cummings with my response at lines 15, 16, 17. The court had directed, and we put in those submissions on 18th June. Now, Your Honors will also observe that the date of the hearing, the date of this transcript when this hearing took place, is the 7th of October. So, having been notified, May, by the affidavit and answer that you're out of time, you have problems, fix your house. June, submissions, you're out of time, you have problems, fix your house. Another 4 months elapsed until we're back in the Court of Appeal. And there is no application for an extension of time. There's no application in any way, in any form, to fix your house. And that leads to this transcript. So in this transcript, Your Honors, I had mentioned the word subjectively, and I have been guilty of subjective reading of this transcript. And what I noticed is that Your Honors, who did not have the benefit of being present, read it with greater objectivity and noticed instances where there are unclear statements. So it will say statement unclear.
To also be clear, Mr. Jonas, by how long are you saying that Mr. Dutherlin was out of time? Because it looks like you're talking about 6 months.
To file the application out of time by slightly over 4 weeks, less than 5 weeks, and we are agreed on 4 weeks. We'll use that as a rule of thumb. To serve that application, another 6 months.
So is this service that you're talking about now?
I'm talking about the length of time that the appellant before you had to correct its position and to present to the Court of Appeal material that the Court of Appeal needed to rely on to justify any extension of time. The Court of Appeal cannot act apropos nothing at all. And
Counsel, I just wanted to follow on from the point that you just made about the failure to put before the Court of Appeal material that could allow it to make an informed decision about whether an extension of time should be granted. I think that's the point you just made.
yes, please.
Earlier, I had referred to Order 2, Rule 35, which speaks to the filing of a motion, speaks to the filing of an application supported by an affidavit showing good and substantial reasons. Mr. Dutherlin did point out that that provision is located in the part of the rules that govern the filing of an appeal and which govern enlargement of time for the filing of an appeal. He pointed out that in the instant case, there was an application for leave to appeal. He noted that Order 1, Rule 1.8, gives the Court of Appeal a general power to enlarge any time frame that may be applicable or to depart from any rule. What I wanted to ask is, what would you suggest should be applicable in circumstances where you're not dealing with Order 2, Rule 35, which, as Mr. Dutherlin is arguing, is expressly applying to instances where you're seeking an enlargement of time for making an appeal? There's a general power to enlarge time under Rule 1.8. Do you have any views on what should be done in those circumstances so that in an instant like this, the Court of Appeal would have before it the relevant information to make an informed decision? Thank you.
Thank you very much, Your Honor. The appeal from the judge at first instance after a trial is as of right, as it should be. You don't like what the judge did, you have appeal, and you have 6 weeks to appeal. In certain matters, and specifically we'll look at summary decisions, the appeal lies to the full court, which is a peculiarity of the Guyanese jurisdiction, a second tier of appeal. I disagree with my friend. I think that the innovation which resulted from Justice Ramotar's ruling has been very helpful. Our full court is very active. There's greater flexibility in the appointment of 2 judges from the puisne judges, and therefore matters are dealt with much more efficiently. So it is one of the evolutions that I think has helped us serve the public better than we have done before. But now that a second tier has heard the appeal, 2 judges or 3 judges sitting down have reviewed what the judge at first instance did summarily, there needs to be something more before you can get to the Court of Appeal. Very similar to the English Court of Appeal and then House of Lords. There needs to be something more. And for that reason, the rules set out that you need leave. So you don't go to the Court of Appeal as of right. 2 or 3 judges have pronounced. So you go to the Court of Appeal and you show the Court of Appeal that there are good grounds for appeal. For that reason, Your Honor, I think by analogy, if you have a right of appeal but you're out of time and you got to show good reason and you got to show interest of justice, if you have an opportunity for leave to appeal and you're out of time, I think that the threshold must be a bit higher. But again, if the court, and I've said this in this forum before, if the court sees a miscarriage of justice, the court got to fix it. I don't think there's a shortcut or a way around it. And Your Honors will not hear me say that a miscarriage of justice should be ignored in any circumstances. That being said, when you do get to the Court of Appeal, however you get to the Court of Appeal, late, in time, out of time, verbal application, written application, and Your Honors, in terms of the written application, I point out that the Court of Appeal rules are specific for leave to appeal from the full court. You must come in writing. So if you're asking the full court can give leave. You go to the full court by way of summons supported by affidavit, the affidavit showing good grounds of appeal and important issues to be determined, or if you're going to the Court of Appeal for leave to appeal, by motion supported by affidavit, similarly showing grounds and a good appeal. It's not done verbally. Therefore, by analogy, I respectfully submit, although we know Order 1 Rule 8 permits, and it doesn't say an extension of time specifically, if my memory is right. It says a deviation from the rules. You can ignore the rules. In essence, that's what it says. In cases where the interests of justice require it, again, that goes to the flexibility and my respectful view of the miscarriage of justice. So we are back to square one. For us to impugn the decision of the Court of Appeal in this forum, we must be satisfied that the Court of Appeal had before it, first, the application for the extension of time, however made. It could not act on the application for leave to appeal because that was out of time. It needed to fix that before it acted on it. And in order to fix that, it needed the application for extension of time made verbally or in writing. I don't believe the Court of Appeal could have easily acted on a verbal application given the timelines I've just recited to Your Honors. Application for leave to appeal December. Service not effected until the Court of Appeal informs us in May. Written submissions, affidavit in answer,
Mr.
and
Jonas,
then until October.
I don't want to disturb you. I'm just trying to make a note of what you said. You seem to be saying that the Court of Appeal, to act, you've explained the 3-tier process, even for leave, must have an application by motion to the Court of Appeal supported by affidavit. And that must show good grounds of appeal. Because in this case, there was also a default in time, you were saying, and this is what I just want to be careful about in terms of understanding what you're saying, there must have been also either a verbal or written application for an extension of time. Is that what you're saying?
Yes, please.
May I ask you, is it the practice of the culture in the court at this time, or when this was done, that verbal applications are something that is normative? You have a mixture of verbal and oral, and you all proceed that way.
Your Honor, at the level of the full court.
Before the full court, you have verbal and oral. Verbal and written.
Forgive me. At the level of the full court, the full court pronounces, and you don't like the decision. I have seen counsel stand up and say the 3 words, leave to appeal. And the court says leave to appeal almost automatically. Recently, that has changed. And in fact, I took the point successfully before Justices Arnanan and the learned Chief Justice, as she done was, that it could not be done that way, and they agreed. And there has been an evolution of that process from that informality, that flexibility.
So you would say that in Guyana right now, during the time of this appeal, you were in a sort of a transition where you are now moving towards more of an insistence, make it in writing, etc. But there was, at the time, a culture of oral applications.
Forgive me, sir, I qualified that by saying in the full court.
Oh, sorry,
Because-
so no, yes, I heard that, but so what happens in the Court of Appeal? Because that's where we are, right?
In the Court of Appeal, the court will often act on its own motion if it thinks it's the right thing to do. But if it does not, and counsel is making an application, in my experience, that application is made in writing. In fact, counsel may be invited to make the application in writing. But I cannot say that I have experienced with any, I can't say I've experienced a situation where the court has heard a verbal application, we need more time, and said granted. Not if it's opposed. Justice Rishi Persaud, yes, please.
I saw the Justice of Appeal, Rishi Persaud, was trying to say to Mr. Dattin, well, you can make a separate application. Is that what you're speaking about, that the Court of Appeal itself may guide or direct counsel as to the application that could be made? And is that what Justice of Appeal Persaud was trying to do there? I see he was, and I use the word very kindly, cut off, but it was online, so that's always a difficulty.
Yes,
Sometimes
yes, it
one
is.
feels that your colleague is finished with the statement, and it may not be so.
I think, Your Honor, that the court was pushing my friend to choose a decision, to take a decision. My friend before that court was speaking of an amendment, and he didn't elaborate. At that time, I was puzzled, but he has, before Your Honors, elaborated that he intended to amend the existing notice of motion to include that prayer for the extension of time. Your Honor, I think that he could have filed in a single motion an application for the extension of time and for leave. I think given that we were already in the walls of the court, we were already in the House, he would have had difficulty trying to justify that by an application for an extension of time made after to retroactively fix the application for leave to appeal. But again, if the interest of justice required it, the Court of Appeal has that lovely flexibility under Order 1 Rule 8. In this case, I don't think any of that happened because nothing was put before the Court of Appeal to say, this thing's unfair, here's why it's unfair, exercise your discretion. And no, not at all, Your Honor. There's no miscarriage of justice here. I'm, in my small voice, satisfied of that.
My sister has referred to it on more than one occasion, Order 1, Rule 8. The words are fairly stringent. They go further than normal rules go then and say that the Court of Appeal, when dealing with this issue of enlargement of time, may direct a departure from these rules in any other way. You don't often get that as you go through CPR or even what we used to call the old rules. And this is where this is required in the interest of justice. Very interesting.
By the Court of Appeal before the
I mean,
advent.
they could do anything in the interest of justice. That's what you're saying.
Yes, but the qualifier, the interest of justice, was rigidly applied. It had to satisfy that threshold. And, Your Honor, I'm working from memory. Forgive me, as I said, there were a lot of issues, but there are two cases, application by Chandrauti and application by GTM, where I believe the Chancellor back in the 70s and 80s had addressed that. Your Honor, my memory is application by Dhavanie Persaud and application by GTM. That's my memory, which is increasingly fallible. No, please. This did not arise in my mind at all at the time.
Mr. Jonas, before you move on, just to continue the conversation on Order 1, Rule 8, and the power and jurisdiction of the Court of Appeal to depart from the existing rules in the interest of justice. In the hearing of the appeal, was there any opportunity given to discuss the alleged errors of the law in the lower courts? That is to say, the declarations made in relation to that they were representatives ad litem, the declaration made as to limitation and as to fraud. At the first instance, there were certain orders made, yes?
Yes, please.
Right. So under the interests of justice umbrella, which is what we are looking at right now, in the hearing before the Court of Appeal, was there any opportunity given to interrogate that? The errors, the alleged errors of what may or may not have happened below.
Your Honor, in my respectful view, there was manifest opportunity to. Yes, please, sir.
Okay, good, yeah.
If I can point, Your Honor, to page 334 of your record. And Your Honor, let me preface this by saying that first, there needed to be the application for the extension, and then there needed to be the submission to the court why it should be granted, why it exercises
So,
discretion.
yeah, what I'm interested in
Two
is, did we
stages.
get to the Part 2 stage before the Court of Appeal?
Your Honor, I think opportunity was given for the Part 1 stage,
Yeah.
and when that was not followed, so when no clear application, and again, I'm referring to page 334, when the Honorable Justice Cummings says, you're applying for an extension of time, and my friend says, no, no, please, Your Honor. And that is repeated. So she then says, so you stand or fall by what you've presented. And he says, essentially, Your Honor. She is giving several opportunities, and as Your Honor has observed, Justice Rishi Persaud similarly gave opportunities to say, do you have an application? What do we do? Now, after.
But all right, I'm just trying to just focus on, yes, so that what you call stage 1 is the extension of time, correct? What I'm asking about is your stage 2. In the interest of justice, the interrogation of merit then, the substantive merit of, or demerit of what happened in the lower courts around the issues of limitation, fraud, and representative status. Those were the 3 core issues, substantive issues that are critiqued, or was sought to be that were being sought to be critiqued. Was that interrogated in the Court of Appeal? That's what I'm trying simply to ask. If the answer is yes, I'm happy with that.
Your Honor, all that was done is that the court, at the end of this prolonged exchange, asked my friend, do you have anything further to say? And he said no. So that is all that I have.
So coming out of that, Mr. Jonas, just to be clear on your view of this, if your learned friend had provided reasons as to why there should be an enlargement of time, the Court of Appeal would have had a chance to interrogate those reasons and make a decision.
I believe the Court of Appeal would have listened. Yes, please, Your Honor. The
As
Court
to
of Appeal
whether
was that way disposed.
It was in the interest of justice to extend the time.
Your Honor, I don't think that question even came up because there's no application. But the Court of Appeal, that court, would have listened. Yes, please.
But you're saying that in the absence of the application, in the absence of reasons, in whatever form, affidavit, otherwise, the Court of Appeal did not have an opportunity to interrogate that issue.
That's correct.
Okay. Now, my question to you is, what is your view on our ability to interrogate that issue? Because we are really being called upon to decide whether the Court of Appeal erred or not. And if the Court of Appeal did not have the material on which to base a decision about whether it was in the interest of justice to enlarge in the time, do we have or should we exercise the jurisdiction, the discretion to decide whether, in our view, it is in the interest of justice for there to be an enlargement of time?
Your Honors, Your Honor, you are often inclined to ask me a question that makes me try to put myself in that difficult chair. The rules, as we know, I won't belabor it, require Your Honors to decide that the Court of Appeal was wrong. That's what an appeal is. An appeal here is a review of what the Court of Appeal did and the determination that the Court of Appeal was right or wrong. If the Court of Appeal wasn't wrong, we're stuck by it. In your difficult chair, Your Honor, for me, and I will be consistent in this, as I've said earlier today, if I see an egregious miscarriage of justice, I will fix it. And therefore, I believe that the rules as they exist do permit this court to fix an egregious miscarriage of justice. But it is difficult.
Council, President, go on. After you go on.
Yes, I'm not sure I'm quite following you. Our function is to examine the correctness of the decision by the Court of Appeal.
Yes, sir.
So in what regard would we be saying that the Court of Appeal was wrong in circumstances where A, there was no application for an enlargement of time, and as a consequence of that, B, there was no opportunity for the Court of Appeal to decide whether the interests of justice required for there to be an extension of time? In what way would the Court of Appeal have erred? I know you're not saying that they did, but I'm just trying to figure out how is that argument constructed? What is the scaffold for that argument if the Court of Appeal did not have an application before it, and if there were no reasons given to the Court of Appeal as to why the application ought to succeed?
Your Honors, if I can refer you to pages 1146 to 1148 of my submissions. I hope I answered that question, sir, and I come to the conclusion at paragraph 25 that 1146 to 1148. At page 1148, paragraph 25, after the discussion of the interests of justice and that kind of thing are dealt with, Your Honor, I come to the conclusion that the argument was not presented to the court, and therefore there is no error demonstrated by that court. So in the absence of an error demonstrated by that court, if this court is a court of appeal whose function is to review what appeared before the court below and the determination of the court below, you may be stuck, Your Honor, if you come to the conclusion that the court did not err. You see, Your Honor, we deal with the finality of judgments at first instance very easily. And we say that if a judgment, there's a trial at first instance and the judge hears the evidence and comes to a decision, he might be wrong, but there's finality of judgment, and the parties will not easily be allowed to come back on the same issues to say, we want to raise this or we want to raise that. That is a clear and righteous, self-righteous, if I may say so, approach the appellate courts take, and rightly so, because there must be a finality of judgment. So if we apply that by analogy to the Court of Appeal, Your Honors, where we are now in the stratosphere of a more academic approach, Your Honor, it's hard to depart from that. The Court of Appeal has material before it. Are we allowed to say, I am taking a decision on material which was not presented to the Court of Appeal and I'm ignoring the issue of finality of judgment? And that is difficult, Your Honor.
Where does it end? That's opening a very interesting avenue, I think. Thank you.
Council, whether or not the Court of Appeal erred, you will agree, will turn on whether there is a hypothesis or even a finding that interest of justice is engaged, isn't it?
No, please, sir. It's a pleasure to meet you, sir. The Court of Appeal cannot be said to have erred if it acts on the material before it, but then is criticized for acting on material not before it. That is the difficulty.
All right. We have a transcript. I believe that it is possible for interpretations to occur on the basis of this transcript. And my learned sister, Justice Ononewu, had taken us to passages in the transcript that would lead, at a minimum, someone to say Mr. Dutherden was expressing a desire to apply for extension of time. Let's leave it at that. Let's accept that the minimum, it is indicating a desire to apply for extension of time. What harm could have been caused if the Court of Appeal at that stage would have said, all right, we're going to stand this down, grant an adjournment, Mr. Dutherden, you apply for your extension of time with the material in support. But even before getting to that point, for coming to that, would have required you to show, do you have any prejudice to argue that will stop us proceeding in that way? So we look at it from the perspective of, all right, there's a substantive claim being made by Mr. Dutherden. He's out of time to make it. Can the error, can his fault have been cured by an adjournment and costs imposed on that adjournment in order to allow him to argue his point, to see whether he has anything to say on why he was out of time, assuming, of course, you had made your argument as to prejudice on your side, and he's shown that there is none, unless, of course, you show that there is prejudice to proceed in that way.
Yes, I thank Your Honor for your guidance there, because my inference from what Her Honor had said was the opposite, that having been given opportunities to make that application, to put in the application for the extension of time, my friend didn't take advantage of it. But if there is to be gleaned from the transcript an inference that my friend sought an opportunity to ask for an extension of time and was refused, and Your Honor, I'd be grateful for your guidance if I'm wrong on that. The ground of appeal to this court should be that the Court of Appeal erred, having received an application for an opportunity to put in an extension of, an application for an extension of time, they refused it. But that's not what's before this court. What's before this court is the error of the Court of Appeal in not appreciating a miscarriage of justice. So we have grounds of appeal before this court, and I do not see before this court any suggestion that I asked for an opportunity to put in an application for an extension of time, and the court wrongly refused. That's not before us. So with great respect, sir, I do not believe that that is also borne out from this transcript. I don't believe that there was a request and a refusal in terms of, please give me an opportunity to put in an application for an extension of time, and no, you refused.
Can you go to internal page 2 of the transcript? I know it's in different places on the record, but looking here, the version I have would be page 397 of the record. Other references have been made to it in other places, but the one I have says 397. Are you there?
Your Honor, the top line is, Mr. S. Dutherden, we do not have an application before the court for an extension.
No, the top line. This is the transcript.
Yes, please.
All right, what I have at page 397, internal page 2 of the transcript.
Internal page 2, thank you.
Internal page 2.
I'm not hearing at all. Go ahead again, please.
I'm not hearing, exactly, there we are. Now look at line 21. Your Honor, I have received, this is Mr. Datadin speaking. Your Honor, I have received the submissions of senior counsel, and my only application to the court today, or hopeful application to the court today, was to apply for leave to extend, for extension of time. What is he saying there?
That he is, in that moment, asking for an extension of time, not that he is asking for an opportunity to put in an application for an extension of time.
And then we go again at page, the next page, internal page 3. Again, line 10, inaudible incoherent speech. Now, my only application today, Your Honor, was if the court would permit me to amend the application that is before me or to file a separate application as it relates to the period of time.
Could I invite?
Is it possible that this is indicating a minimum of a desire to apply for extension of time?
Could I invite Your Honor, please, to just look at the lines before that?
Yes.
Lines 5, 7. Justice, Honorable Chancellor Cummings, you're filing an application for an extension of time, so she has distinguished an application now made verbally, saying please for more time, from do you propose to file an application for an extension? And my friend says no, no please, Your Honor. And then my friend says, no, my application today is if Your Honor would permit me to amend the application.
The meaning, not file a separate, but amend this to include that. Is that what you understand that to mean?
Your Honor, I wouldn't fight that fight. If that's the inference,
No, I'm
I think it's
asking
fair.
you. We all reading the same transcript. There's a conversation going on. It starts where you started, and then he says, no, I don't want to file a separate application. I want to amend this. Amend this to do what?
Your Honor, with great respect to my friend, I think he was on his feet trying to figure out what he needed to do.
That's possible. That's possible. But my question to you, Mr. Jonas, is you were given an opportunity at that point. I think you tried to seek, again, I don't want to overinterpret the transcript, to seek your help. There was a point where the court said, what do you have to say? It invited that. And you say one side is 6, the other side is half a dozen. That was the sum of your submission. You didn't say, I do not object if he wants to amend. You didn't say that. Now, do you have any, could you have argued any prejudice that would have resulted to you had that matter been stood down then so he could be given an opportunity to file?
Your Honor,
What would be the prejudice to you that could not be cured by costs award?
Your Honor, the options that were presented to me by the Learned Chancellor at the time, the two options were strike out or withdraw. And if Your Honor reads before, Your Honor will see Mr. Datterton says, is Your Honor going to permit me a withdrawal of the application? This is internal page 6, line 18. Is Your Honor going to permit me a withdrawal of the application? This is the extant application for leave to appeal. And she says, in all of this, the other two judges have advised you how to proceed. And then Mr. Datterton says, is the court permitted to withdraw? Because then that would be the path we would take. And if Your Honor reads previously, you will see that the alternative to withdraw was that we throw you out, you struck out.
But Mr.
Sorry,
Datterton,
yeah,
if I could just say very quickly though, because I want to go back to where we were before. Because when Mr. Jonas, when Mr. Datterton mentioned, would the court permit me to amend the application that is before me, I take it he means that the one that he had already filed, he would amend, or to file a separate application as it relates to the period of time. So he's obviously speaking about an extension of time. Immediately, though, he's told no.
Yes,
Mr.
please.
Jonas, sorry, no, Mr. Datadin, you move the court.
Yes,
And
please.
then, so I want to know how the conversation went from permit me to amend or to file an application to you have to withdraw or else. I want to know.
Thank you.
That is a little strange.
Your Honor, thank you. My response was in the specific context of two options put to me, which was much later down in the transcript.
But
And
Mr. Jonas, the options of strike or withdraw were put to you or Mr. Datadine?
Your Honor, it was discussed with Mr. Datadin. Do you want to withdraw? He said, if you give me the opportunity, I'll withdraw. And then I was invited to say something. I don't know why, so I don't think it was necessary.
Okay, you weren't under the gun at
And
the
my
moment.
response was, if you withdraw or if you struggle,
Okay, yes, yes. Because for you, it's the same effect, right?
6 of one, half a dozen
Got
of
it,
another.
got it,
Yes,
I
please,
got
sir.
it.
No, Justice Rajnath Lee, going back to your question, I think that the point has resonated, and I'll say it again, that my friend was in a position, and this is one occasion I'm not going to defend him because I think that there was notice given there. There was an affidavit filed months before. But he was in a position that he's now confronted by the court and has to decide what to do. And therefore, a number of opportunities on his feet were being considered, and they were shifting ground. So if Your Honors look in one location, you will see, you want an extension of time? No, Your Honors. If Your Honors look in another location, you will see, Your Honors, we need an extension of time, or we want to amend what is here. There is shifting ground. In this court, I respectfully believe that whether or not this court wants to treat this transcript as an application for an extension of time, then what is necessary is that this transcript must contain the reasons why you must get more time. And I do not see that was embarked upon. And Your Honor, Justice Anderson, I believe that was point 2 that you were asking. I'm sorry, Justice Jamadar, that was point 2 that you were asking, the second limb. But it wasn't embarked upon. And to me, it needed to have been embarked upon. And when the court said, do you have anything else to say? That is the time to say, there is a miscarriage of justice going on here. And these are my grounds for it, and I will ask Your Honors, and Your Honors will forgive me, I have done so, maybe it's not as polite as it needs to be, to make a note for Your Honor's record that I believe these are the reasons there's a miscarriage of justice. But that was not done. Yes, please.
Not putting on the mic. Thanks, thankfully. Mr. Jonas, the grounds of appeal, at least what was in the application for leave to appeal from the full court to the Court of Appeal, would have generally indicated to the Court of Appeal what were the errors alleged?
I don't believe that it did.
Okay.
And if I can refer you, please, to page 416 of your record, where that is set out. Your Honors will see that there's a chronology of events set out there. We filed, defense filed, so the paperwork is there. And Your Honors, that's not a bad thing because this turns on the paperwork, and none of this paperwork is in dispute. Whether it's the power of attorney, the substitution, the so-called promissory note, none of those things are in dispute. They are all documents of record and public documents of record and therefore admissible. And I'll deal with this if the opportunity arises to explain why, with great respect to the learned Chief Justice, I think she did exactly the right thing to look at these documents, which were all of public record.
Yeah, no, just wanted to note as well that when Justice Rishi Persaud, I think he was the one who gave the very short judgment in the matter, he did point out that they had seen your submissions, and your submissions contained the merits of the appeal. So I just looking at it very, very broadly for now.
Thank you very much.
There were certain things that were before the Court of Appeal.
Thank you
that
very
they
much.
perhaps could have and may have on another day interrogated.
Yes, if properly moved. But Your Honor, I will say honestly, I don't think that the end result would have been different because what happened at first instance and what happened in the full court, to me, were exactly what needed to happen. Your Honor, there's a litany of problems in what took place. This thing is worthy of a mystery novel. The pronote, if Your Honors will allow me to start with that. It's at page.
Just to put a head in, you're looking at the merits, as it were, the substantive merits or demerits. Is that where you're going to say that even if we look at that, we will not find arguable grounds for miscarriage of justice? Is that, I'm just trying to see where we're going, yes?
Thank you, sir. I'm glad you raised that, because this is where, speaking for myself, I really do need the court's guidance. Justice Rajnathli was very kind at the leave stage to say to me very clearly that the court is moving away from the body of judicial precedents dealing with issues of leave to appeal and focusing on issues of importance, whether there are good grounds of appeal. And I'm grateful for that guidance. But it did not leave me with a target. So I did not know, and I sat back when my friend was on his legs and Justice Anderson, president of the court, said, well, we're here to deal with an appeal from the Court of Appeal, when my friend was discussing the merits at first instance. So I respectfully agree, but does the review of what happened in the Court of Appeal include a review of matters which were not before the Court of Appeal? Because as we have, I hope, settled, if it wasn't before the Court of Appeal didn't err, didn't make any mistake in not taking into consideration what wasn't presented to the court. So we are now here addressing statute of limitations. With great respect to my friend, I don't agree with him on the issue of the fiduciary duty. And for me, the central point, which I think he skipped, is fraud is not fraud on the estate, although there was a claim in the statement of claim for conspiracy. It's fraud on the court. You don't set aside a decision of the court unless the decision was obtained by fraud. So fraud on the court. So we have those three causes of action at first instance, but none of that was traversed in the Court of Appeal, and therefore do we traverse it here. If Your Honors, and Your Honors, I ask for your guidance, if Your Honors perceive a potential miscarriage of justice, and Your Honors wish the issue to be aired, I am happy to do so. But I do not know what the criteria are for the determination of this appeal. Is it an material before the Court of Appeal, we don't see anything wrong, we don't look behind it, or is it, at first instance, there may have been a problem, and therefore, although we don't disagree with the Court of Appeal, we want to hang out all the laundry. I'm grateful for any guidance on that, because I'm happy to explore it, please, Your Honor.
If I may try, just try, in your framing of what the court might do, it looks like you looked at it only in terms of granting the leave to appeal. Is it possible that a remedy could be, well, there might have been a need to explore why there was a lapse in not meeting time, inquire into that. That application for extension of time afford that opportunity for the application for extension of time to be made properly with the evidential material put in to be examined, because at the end of examination of the evidential material in support of application for extension of time, the result might be imposition of costs against the party or against counsel on a personal basis, or to say, look, the Court of Appeal was entirely correct, end of case. So, is the only option before us today, that's the question to you, to determine the leave to appeal, or can we also be looking at the matter of extension of time and leave the decision at that and give opportunity for that to happen? Just a question. I'm not making a decision yet. I'm throwing up all the things that come out of this case as I'm seeing it.
Your Honor, I may have inadvertently conflated my discussion in my own mind, and if so, I apologize. To my mind, the application for leave to appeal in the Court of Appeal could not be heard because it was out of time. For it to be heard, it had to be fixed. It could not be fixed unless an application was properly before the court to fix it, supported by the considerations which are relevant for the exercise of discretion, or the court saw something so problematic that on its own motion, it said, on order 1, rule 8, we're going to fix this and move ahead. So if the appeal to this court, the Court of Appeal having struck it out, if the appeal to this court is that the Court of Appeal failed to see something so egregious, such a miscarriage of justice, that it erred in not exercising its own discretion, that is one thing. But for that to be vindicated, for that ground of appeal to be vindicated, there would have to be material before the Court of Appeal to show an egregious miscarriage of justice, which there obviously isn't. So the next review possibility by this court would be to say the Court of Appeal erred by failing to or refusing to give an opportunity to make that application for the extension of time. That is not a ground of appeal before you. So for this court to deal with it, the court may well say, amend your notice of appeal, we want to discuss that. The court may well ad hoc say to me, discuss that. But it was not a ground of appeal. There's nothing before this court to say, Court of Appeal acted wrongly because they should have given me a chance to file an application for the extension of time so that it could have exercised its discretion to give an extension of time. That's not a ground of appeal. So I can try my best to answer it, sir.
My feeling, Mr. Jonas, is that you ought to respond to the grounds of appeal that we have before us. Thank you.
I'm very grateful for that, sir. In that case, I will go back to my original query, please, Your Honors, and ask if I can now embark, or if I now should embark, on an analysis of the correct decision of the learned Chief Justice made summarily.
Mr. Jonas, bearing in mind that what is before us is an appeal from the decision that was actually made by the Court of Appeal. And here I'm looking at the last page of the transcript. I'm at this stage not referring to page numbers, but I can say it is the last page of the transcript.
Internal
I believe
page
it's the
8,
last
please.
page, where
Yes.
the last thing said is proceedings ended at 8:27, right? If we look at lines 1 through 7, that captures the decision of the Court of Appeal. The Court of Appeal says this matter being about a month out of time. There's a reference. The Court of Appeal says, we've noted Mr. Datadin's reluctance to withdraw and discontinue this matter, which is clearly out of time. We're guided by Order 2, Rule 2.1 of the Court of Appeal rules, and they speak to the prescription of the 14-day time limit. The court says, in the circumstances, this appeal is struck out. I don't see from this decision that the Court of Appeal would have been guided by anything other, that the matter was filed out of time, and as a result, the court struck the application out. In other words, I don't see any consideration by the Court of Appeal of the merits of the application for leave to appeal. What I'm seeing here is a determination made by the Court of Appeal that because the matter was filed out of time, it's going to be struck out. I'm raising this because I'm not clear on how this court would be embarking on a determination of the merits of essentially the finding of the High Court in circumstances where the decision that was made by the Court of Appeal, which is being appealed, is a decision to strike out the application because it was filed out of time. And what I understand is before us is the very clear issue as to whether the Court of Appeal was correct to strike out the application for leave to appeal because it was filed out of time.
Thank you, Your Honor. That does narrow my focus, and I'm grateful. If before the Court of Appeal there was material to show an egregious error, the Court of Appeal would have been wrong to say we just strike any out. If there was material before the Court of Appeal to show that an application had been made for an extension of time, the Court of Appeal would have needed
Mr. Jonas, let's stay on point one. You say if there was material before the Court of Appeal to show an egregious error.
a miscarriage of justice, yes.
Miscarriage, which, right?
I did say error,
Yeah.
yes, please.
No, whichever, both are fine. Having occurred where and when?
In the court below.
Right. So that would be on merit.
Yes.
Okay. So your submission is, if there was evidence before the Court of Appeal that demonstrated an error in law, egregious error, miscarriage of justice in the courts below on the merits, that would be a relevant consideration that they should have taken into account.
Yes, please.
Let's pause there. In their determination of the case, as our sister has read to you, they only indicated that they considered time, and they quote Order 2, Rule 3, not Order 1, Rule 8, but forget about whether that's an error of law. For now, is there any evidence in their decision that they considered what you have just said?
To answer your question clearly, there isn't.
There
But, Your
isn't.
Honor, with great respect, I wonder if that's the question.
No, you
To-
just said to, I am not, I am just trying to understand what you are saying. You said that if there was evidence before the Court of Appeal, and you said, I believe you said egregious error, but we have agreed, then that was one thing you said. And so I am just clarifying for us all that in its decision, there is no evidence that the Court of Appeal considered that at all. And we agree on that.
Except for one thing, please, sir. When you put it that way, the suggestion is that the point was argued before the court and ignored. But the Court of Appeal also didn't consider a negligence question because it simply didn't arise. And it can be
Sorry, you didn't consider what?
a negligence question because it didn't arise.
No,
So the
but,
court can
but
only,
the application before the Court of Appeal was for leave to appeal.
yes, and I think I'm
To
answering you,
leave to
sir.
appeal on the decisions of the courts below,
The full court, yes, please.
on merit.
Yes, please.
Yes, so what they were moving the Court of Appeal to do was for leave to appeal
Yes.
on alleged errors, miscarriages, whatever you want to call it, that occurred at the lower courts. I have categorized those as findings of fraud, improper findings of representation, and what's it? The other-
Fiduciary.
Yes, the fiduciary duty, right? That is the substantive application that was before the Court of Appeal. The application for leave to appeal against alleged errors on the merits. Agreed? Yes. However, they were out of time. Agreed? And the Court of Appeal decided that...
I keep getting turned off, sir. I'm sorry. So I might be answering when you're not hearing me.
That's okay. I think it's actually automated. I think when I'm speaking, I'm on and you're off. And I think the system is sophisticated. So I don't there's no culpability on your part.
Your registrar is not depriving me of a fair hearing. So.
All right. Okay, good. But the Court of Appeal decides, only appears to consider the default in time. Now, I suppose for me, the conundrum is, as a question of review of the Court of Appeal's decision, whether in determining what to do, given an admitted tardiness in relation to time limits, what should the Court of Appeal, how should the Court of Appeal have approached that question, and whether or not a factor in its consideration should have been what you just said it should have been?
Thank you, sir. And I hope I am answering that when I say that that can only be a factor in the Court of Appeal's consideration if the point is raised before the Court of Appeal, or if the material before the Court of Appeal.
But
And
Mr. Lawrence, where I'm confused a little bit is, isn't that what the leave to appeal application was all about?
no, please, sir.
No, okay.
The leave to appeal application is good grounds of appeal and important issues to be determined. That's the standard criteria for leave to appeal from the full court. I think it's very similar of Court of Appeal to House of Lords. So good grounds of appeal, important issues to determine. When you're out of time and when you're on the back foot, I believe the threshold is a bit higher. And when you're going to ask the court to act on its own motion or on a verbal application under Order 1 Rule 8, I believe it's higher still, as this court has discussed the highest threshold, which is an egregious miscarriage of justice.
Higher in relation to merits?
Yes, please.
Okay, good, yeah.
So, for me, in order to criticize the Court of Appeal for not finding or not treating with the question of whether there was a miscarriage of justice or whether something was happening, it would have to be shown that it was argued before the Court of Appeal, or at the very least, the Court of Appeal had the material before it to allow the Court of Appeal to draw a conclusion, something is wrong that needs to be fixed. And I do not believe the point was argued, it wasn't even raised. And I do not believe on the application before the Court of Appeal, which is at page 416 of your record, that that even came up.
Okay, thank you.
Therefore, the Court of Appeal can't be criticized because it did not address something that it wasn't asked to address. Your Honors, there are a number of issues I wish to point out that speak to the miscarriage of justice. And I hope Your Honors will indulge me, because it may be that I'm going outside the ambit of what Justice Anderson has clearly said to me is relevant, but I don't propose to take much time on it. It's just my friend had raised it, and I really would like to answer. Please.
Yes, you raised it, so please.
I'm very grateful, sir. Your Honors, if I can refer you, please, to what's called a pro note. And I will not belabor the arguments which are in written submissions before the full court and on your record as to what a pro note. It must be a sum certain in money. It can attract interest, but the interest must be calculable mathematically, so 6% a year from date of issue until fully paid. You look at the face of the pro note and you can calculate mathematically on the 1st of June, this is how much money is owed. That is the definition of a pro note. As soon as you start wriggling on those issues, it's no longer a pro note. If you have an alternative means of paying, I'll give you my house, it's no longer a pro note. A pro note is like a check. $10 together with 10% per interest from today until fully paid. That's the end of it. So those are in the submissions before the full court, please. The reason that is so vitally important is that a pro note changes the burden of proof. If I hold a pro note, I don't have to prove I loaned you the money. I show the court the pro note, and the court presumes that you owe me a debt. Whereas if I don't have a pro note, I just got a contract, I have to prove that I advanced the loan to you in order to satisfy the court that it must give judgment for repayment of the loan. So it's a fundamental document, and it is very important to decide whether this is a pro note or not. The pro note is at page, I hesitate, Your Honors, page 243, where it is described. Your Honors will see the pages are numbered. There's a number at the top and a number immediately below it. This is page 243, immediately below it. And the reason I'm going here, Your Honors, is because Your Honors have before you what the Court of Appeal did not actually have. But you have the documents from first instance. Can I go on, Your Honor? Have you found the pro note?
Is there a way, Mr. Phillips, that you could help us? Can you display it on the screen or not?
And next you come to Mr. Jonas, you have to come with a little help.
Junior.
Mr. Jonas, you have to come with Mr. Jonas Jr. to help you on the monitor to show us some information.
Interesting you say that, sir. In answer,
I'm just asking,
you put
from
it
where
up?
you?
Put it up on the please.
It's okay. He-
I'm gonna keep
no, yes, I'll pull it up.
Your Honor, it's interesting you say that. I can proudly say that,
I know, I didn't say that out of ignorance.
well, that's very kind of you, sir.
I've seen the good photographs and realized that juniors can be more handsome than seniors,
And smarter too, sir.
and smarter too.
In fact, I think that might be the objective of a family, to make offspring that do better than you do. Ms. Angano has been kind enough to say she'll put it up. Or I can present a physical copy to the court if I can get this to work. In answer to Your Honor's suggestion about having counsel to assist, I'm afraid the respondent didn't have the financial resources that the appellants have. This is the case. Thank you very much. And then I just move it around.
Mr. Jonas, if you look at the monitor on your left, you'll see it there.
Thank you very much, sir. Yeah, that's perfect. Thank you. Thank you, sir. More confusion, but all right, I'll try. Your Honors, I, Shamsundar Persaud, owner of properties, agree to repay total money to Satyanand Persaud, 400,000 United States dollars. They are required by installments of 50,000 US every 6 months from this date being 27th June 2010. The paperwork before Your Honors reflects the statement of Mr. Satyanand Persaud, it's in the record, please, that no payment was ever made. So let us not quibble as to whether there's an existing loan or whether any payment was made. No payment was made, he says so, and let us focus only on the statute of limitations. The breach, therefore, would have occurred in December 2010, when the first installment of $50,000 was not made. That's when the breach would have occurred. No one can dispute that. And therefore, the cause of action takes place in December 2010. Satyanand dies in 2018, and this litigation is filed a year after in 2019. There's no way, twist it or turn it, that this action can be permitted once the defense is raised on the statute of limitations. If it is an ordinary contract, it's 3 years. If it's a contract on a liquidated sum, which is my friend was adverting to Section 3 of the Limitation Act, and I'll ask Your Honor to have regard to it. Section 3 of the Limitation Act talks about bills of exchange or other liquidated sums in writing. The other liquidated sums, of course, to be construed in the context of the previous specific language, which is bills of exchange and that kind of thing. This is not a document that creates a liquidated debt. Because in this document, it says, if after 6 months, you have...
Mr. So what is this? Is this a pro note or not?
Definitely not, sir. It can not even remotely a pronoun.
Good.
So
What is it?
it is an agreement, assuming that it took place and is validly signed and all of that, which we're not getting into. We're making that assumption. It is an agreement that I will pay you $400,000 by 6 monthly installments every 6 months. Oh, I'm sorry, that's what you're getting at. Yes, please, sir, it's a contract. And it's not a liquidated sum. Yes. Liquidated sum is important, please, sir. So I'm going beyond pro note. It's not for a liquidated sum. The reason liquidated sum is important is because I want to make it very clear there is nothing in Section 3 of the Limitation Act which extends the period of action to 6 years for liquidated sums, for bills of exchange and liquidated
So
sums.
why is it not a liquidated sum?
Because it says that if he's unable or unfit to pay, if he doesn't pay within the 4 years, he gets a property.
Okay, so is this at all an arguable issue? Or in your opinion, it's not even arguable,
No, because if he doesn't pay, he gets a property.
right?
So there's no debt anymore. He gets a property.
So that in your opinion, the Chief Justice was right
Your Honor, I don't believe she could have come to any other conclusion,
to
but
say it was not a pro note.
not a pronote. But Your Honor, that wasn't what the Chief Justice's decision turned on. That was what the full court turned on.
Sorry, the full court, yes,
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 please.
you're right, correct. Yeah.
And I don't believe that there is anything that can second guess the full court in that regard. This was not a pronote, but it was presented to Justice Harnanan expressly as a pronote. And therefore, Justice Harnanan was lulled and fooled by the nature of the application made before him and by the appearance of Taij Bahadur, pretended to be on behalf of the estate, to whom he had a duty to say, I consent to judgment on this pronote.
Wouldn't Justice Harnanan know or presumed to know what a promissory note is and the elements of it? When you say that he was lulled and fooled,
That he was, I'm sorry, sir, that he was.
would he not know the requirements of a promissory note? When you say he was
Your
lulled
Honor,
and
a judge is
fooled?
presumed to know the law.
Pardon me?
A judge is presumed to know the law, and Justice Harnanan is a very, very good, very experienced judge.
That's why I say you
But-
say he was lulled and
But I will
fooled.
say, speaking for myself, who is much less experienced, I had to research to decide on what side of the fence a specific document falls. I appeared before this court in Guyana and Republic Bank, and we discussed it ad nauseum, what side of the fence a document falls. Because a pronote can be in foreign exchange. It can be expressing interest. So it does need a bit of examination, but Your Honor, a judge who is sitting down at first instance and has a schedule of 6 FDAs in the morning, when counsel comes and says, here's the defendant, and the defendant says, I consent, I owe the money, it's easy to see what happens, sir.
But if you also had to research it yourself to figure out on which side it falls, what does that say about the claim that the fraud was committed on the court if the judge himself may not have realized it because of a lot of heavy workload he has to do, and you as senior lawyer had to research it? What does that do to the claim that a fraud was pulled on the court?
This is not in a gray area, sir. This one is black and white. This one says, if I don't pay you, you get a house. That's the end of the discussion.
On the statute of limitation, your colleague in his submission says that there had been repeated acknowledgement of the debt on subsequent dates. I suppose is arguing that rolling over of the
Yes.
statute of limitation
And
doesn't. What do you say to that?
the statute of limitations does indeed provide that a debtor, if he acknowledges in writing his debt, starts the process, starts the time counting. My friend hasn't pointed to one written statement by the debtor who is the deceased. My friend talked about some family member and the 2 boys, but my friend has described them as the 2 boys. Forgive me, I'll repeat that for clarity. But there is not before this court or any other court again in terms of the statute of limitations, Your Honor.
Be something to explore a trial with witnesses called?
Yes, sir. And Your Honor, because the question of the limitation is a question of evidence, the fact that it was not alerted to Justice Harnanan and the defendant came to consent in breach of his duty to the estate and to safeguard the assets of the estate means that Justice Harnanan was lulled, he was deceived, and that is why there was a fraud on him. That is one of many reasons why there was a fraud on him.
Just a question that I don't know that I have ever thought of it before, but could the person who consented, Taij Bahadur, who consented to the judgment, is that right? Could the
fiduciary duty to the estate as he was doing.
Unless you have the consent of that person, or
Oh,
whoever you acting for.
and in-
Let's leave it general for
Yes,
now.
please. And in this case, if there are 4 beneficiaries of that estate, 4 children, and the respondent before you, Dhavanie Persaud, innocent of all of this, is living in Guyana, going about trying to process the estate, move things forward, and completely oblivious to what is going on. The result of this, assets, which is attached to the grant of administration of Shamsundar Persaud. It is at page 198. Again, I numbered the documents below. Yes, please. Your Honor, if you give me 1 minute, I will find it and give you the pages. It will appear on yours. Two 261, please, Your Honor.
Could you repeat that, Mr. Jonas?
261, please, Your Honor. Your Honor will see that 260 is the grant of letters of administration, and 261 is the declaration to the Revenue Authority of the value of the estate. Are you with me, Your Honors? Now, matter of R.N. Persaud and GNCB before this court, before we were less fancy, he volunteered to come in junior and turn pages for me. Ms. Angunu has been kind enough to help. No, this is saved. I don't have it in print. No. So it is. Yeah, it's there. Page 261.
There you go, Mr. Jonas. You see, now you have a junior assisting you. Just give us the right page number and we'll get it. Oh, good. 261. If you look at the screen in front of you, you'll see, and then we can move it through. Thank you.
From, no, not from here. Do it from here. Good. That's fine.
Mr. Jonas, while they're helping you pull up the material, please, you don't need to address this now, but try and speak more broadly to the miscarriage of justice issue at some point. Miscarriage of justice issue, Mr. Data didn't run out of time. I hope he takes it up
I
in
will
his
do so,
reply,
sir.
but I need to hear that. Thank you.
So, Your Honors will see at page 261, the gross assets of this estate are $62 million, as certified by the Guyana Revenue Authority. That's something less than 300,000 US. So the effect, Your Honors, ignoring the fact that they owe the bank $50 million, the effect of a judgment against the estate by consent of Taij Bahadur is that there is no estate left. So that 4 children who expect something find that there is nothing there. And this is done by so many shortcuts of mandatory legal processes that a book can be written. For me, Your Honors, the miscarriage of justice turns on, is there a hearing before final orders are made as to rights and liabilities among the beneficiaries, among the parties, and in respect of this claim of a debt that is now 25 years old by Satyanand Persaud. And in that regard, I'll ask Your Honors to have a look at the statement of claim, which is at page 427 of the record.
I'll just advise you, Mr. Jonas, that you have a short time left. By my watch, 7 minutes.
Is it then the case that the complaint there would be that this is not something that is appropriate to be resolved by consent judgment?
I'm sorry, sir, I didn't hear you.
Is it the case that your issue is that in the circumstances of what you've just explained, this kind of matter is not something that's appropriate to be resolved by way of a consent judgment?
No, please, sir, that's not my position.
All right.
There is no way in those circumstances anybody who owed a trust, anybody who owed a fiduciary duty to the estate could have consented. If the effect of the consent is to deprive the beneficiaries of the estate of anything and to give the entirety to somebody who may or may not be entitled, not if there were valid defenses. And given the timelines which Justice Ramoutar extrapolated when my friend was on his legs, you get your power of attorney. A month later, I'm sorry, 10 days later, you do the act of substitution. 2 or 3 weeks later, you're in court asking the court to appoint Taij Bahadur to act on behalf of the estate. Then you file a claim on behalf of the estate. All the while, the pretension of standing, the pretension of being in a position to represent the estate, being based on the power of attorney that you took from the 2 boys, and in a quick sequence of events, you have a situation where Taij Bahadur appears in court without counsel. And that is at page 246. I'm not going to try to find it. I'll ask Your Honor to forgive me. Justice Anderson has given me 7 minutes. Page 246 is the record of the fly sheet before Justice Harnanan. And Justice Harnanan observes Jaigabin for applicant Taij Bahadur in person representing first and second respondent, a man who did not have power to receive service of process of this very action, because a power of attorney does not give you a right to receive service of process. Service of process is, the receipt of service is not a voluntary act. You don't have a choice, and therefore you can't delegate it to someone. So when Taij Bahadur accepted service from the marshal, we don't know if the 2 boys know about it or not, but he appears in person, without representation, accepts the debt, consents to judgment on a promissory note. That's not a promissory note. That is 15 years old, in respect of which no payment has been made, in respect of which clearly there are airtight defenses, none of which he raises. 2 beneficiaries under the estate, totally oblivious that their entire legacy is being squandered by the collusion of these 2 gentlemen. That is an egregious miscarriage of justice. And all that is asked for in the statement of claim, again, I will inform Your Honors respectfully that it is at page 171 of the record, but I'm not going to try to find it. The prayer in the statement of claim, which is granted by the learned Chief Justice, is that on the question of that fraud on the court, where the court's not informed of this collusion of of this sequence of events, that Satyanand Persaud got a power of attorney, and that clothed him with apparent status to say, appoint this man by my substitute to act on behalf of the estate, and then sues the man that he appointed. Paragraph E of the prayer says, set aside the judgment, join Dhavanie Persaud as a party to the litigation, and give directions for the conduct of that action that was before Justice Harnanan. That is how to justly deal with it. Let Satyanand Persaud come to court, and in that trial, not this one, in that trial, say to Justice Harnanan or whoever hears that matter, here's my pro note.
So then you're saying that that is the effect of the Chief Justice's judgment?
This was granted, please, sir.
All right.
So all my friends,
What page is that? That is a order of
it
the
is
Chief
prayer at paragraph E of the statement of claim.
No,
And
no.
I-
46 of the record of appeal is the statement of claim.
Thank you
Then
very much.
Where is the order of?
the claimant's claim against the defendants, paragraph E.
Order of Chief Justice.
And the order of the Chief Justice is where?
Your Honor, I had that close to hand because I know I would need it.
Page
And
794.
inevitably,
Yeah, the passage is talking about.
order granted at the end of her judgment, she says orders granted A, B, C, D.
Right, yeah, okay.
Now,
So,
Your
so
Hon-
wait, Mr. Jonas, just let's be clear. So that if at the end of the day, let's suppose we dismiss this appeal, as the Court of Appeal did, does it mean that the status quo ante that is reverted to is the order of the Chief Justice?
yes, please, sir. So that all my friend needs to do, all Satyanand Persaud and company need to do, is requisition or ask the Chief Justice for directions and have their day in court. That is all. And that's what was asked for. And if I can respectfully point you, please.
So wait a minute. What happened? Did the Chief Justice make any orders about fraud and so on and so on? So,
Thank you, Judge. She found that there was a fraud in the court, in those words, and she found that there was a breach of the fiduciary duty to the estate that was owed by the appellants before Your Honor.
so are those findings that are now preempted from interrogation based on the direction she's going to give? Or is it that all of that, because those are conclusions? Or is it that those are interim or provisional conclusions that led to the order or final conclusions?
No, sir. Based on the paperwork before her, the Chief Justice, in what was a very short but succinct, every time I read it, something new came out. Very clear judgment. The first thing the learned Chief Justice did is she went through the defense, and she said everything's admitted. In fact, even what is not admitted, there are public documents to prove it. And the reason it's not admitted is because the paragraph commences in breach of the fiduciary duty, denied. But the facts are all admitted. She then traces the sequence of events that are admitted, and she looks at the paperwork, and she says, no judge who is informed in an honest way about this sequence of events would say that Taij Bahadur can come to court and consent to judgment on behalf of an estate. That's what she said. With great respect to her, I believe she was absolutely right. And therefore, Justice Harnanan, not being apprised, those facts being kept away from him, was deceived and there was a fraud on the court. In the full court says, yes, we agree. But the full court went further. The full court said that wasn't a promissory note. If it was shown to Justice Harnanan and an intelligent discussion had on it before Justice Harnanan, which it was not, because in the pleadings before Harnanan, it is called a promissory note. Not one or two or three times, but every time it's called a promissory note. If he was informatively exposed to the document and the permutations, there is no way Justice Harnanan could have granted judgment, and therefore it's a fraud on Justice Harnanan to hide behind the cloak of color of authority to act on behalf of the estate, pretend that you're dealing with a promissory note and don't have to prove the debt. Pretend that statute of limitations doesn't arise. Appoint your own brother who has no interest by prior consent, and in that application to Justice Harnan say, Taij Bahadur is going to be appearing, by the way. And that's one of the grounds in the FDA.
Mr. Jonas, I think you're out of time. One last sentence, perhaps, if you have it, or
Thank you very much,
stop
sir.
there.
I will respectfully ask Your Honor, please, to have regard to page 1152, which of your record, which are my submissions at paragraph 40. I quote Sir Geoffrey Vos in the Tinkler case, which I relied on heavily. The purpose of a second action to set aside an earlier judgment is to take the parties back to the position as it was before the trial, so that a new trial on honest evidence can then take place. So where I conclude, please, Justice Anderson, is that if this court wants to say, Court of Appeal got it wrong, there was an egregious miscarriage of justice, then this court has to say that what was asked of Justice Roxanne George and granted by Justice Roxanne George to say, you all fooled Justice Harnanan, let's go back and have a trial where it's properly defended and let's see the merits. If her decision was such an egregious error, an egregious miscarriage of justice, so that somebody's out of court and somebody's out of pocket and the door is now closed on them, then this court can interfere. But other than that, it is very difficult in my respectful view to say that the Court of Appeal, especially since it didn't have any of this information anyway, that the decision of the Court of Appeal had the result of an egregious miscarriage of justice. This solves that. I'm very grateful for your honest time.
Thank you, sir. Thank you. Mr. Datadin, please.
Was yours? Oh, shoot, sorry.
Mr. Dutherden, for my purposes, you may need to start with where he stopped, because that was the essence of my question to you, but you were out of time earlier.
Your Honor,
Yes.
May I just say before you start off that you do have 15 minutes, okay?
Yeah, indeed.
Maximum.
Thank you. Your Honor, I don't anticipate, subject to the court, that it would be so long, except to say, Your Honor, where we were at the last occasion, limitation. Respectfully, Your Honor, Thank you very much, Mr. Jonas, obviously, advantage on, but Your Honor, limitation has to be pleaded. It's a matter of evidence. And if we're going to raise the issue of limitation and how it arises, Your Honor, a unique situation would arise. One is no opportunity was given to produce any evidence to the court. What we have spent our time doing in this court and before is an interpretation of section 3, 6, and 11 put together as to what limitation means. Your Honor, as relates to section 3, it says any promissory note or other contract not relating to land. So, Your Honor, what would arise is whether or not these proceedings that are before the court, whether that contract or that document that evidences the debt is divisible. If it is divisible, then it comes under section 3, and the limitation is, in fact, 6 years. If it is not, Your Honor, and it relates to land, and it's termed to be something that relates to land, then under section 15A of the Limitation Act, there is no limitation in contracts that touch interest or concern interest or things with land.
But Mr. Dutton, you don't want to run out of time again. What your colleague concluded upon is that the effect of the Chief Justice's judgment was to send the case so that we can have a trial on the merits where all these things could be explored, rather than maintain the consent order that was obtained by you or your client. So we go back to square one, let's have a full trial. That's the effect of the judgment. Do you
Your
agree
Honor,
with that
if
or
I
not?
if I may direct the court to page 599 of the record, which is the handwritten part of Justice George's ruling. And what is included there are the orders that are made. It could be seen from 598 that the court refers to 1502 3B for summary judgment. On page 599, we're not seeing your screen. I think you got a cast. Yeah, so yes, I don't know how to make it larger, but Your Honor, look at A. A is a declaration, and each of them are obligated as agents and attorneys of the named administrators ad litem to fiduciary duties. Declaration, the defendants' trustees breach their fiduciary duty. The defendants, by the way, are Satyanand Persaud and his brother, the appellants in this matter. These are not things that occurred. Declaration acting on behalf of the administrators ad litem owed fiduciary duty to the first applicant. So, Your Honor, yes, E of that order is to set aside the judgment, joining the defendant as the respondent in the action, and giving such directions for the conduct of the action. But it doesn't join. This is a proceeding that is finished. No application is made in that proceeding to join, and no order is made to join the claimant. You join in the defendant. The claimant is not a party to the proceedings. What is the claimant doing? I mean, essentially what you've done is put them there. The other thing, which I only wish to go at, page 499 of the record, Your Honor, which is the defense of the first defendant, Mr. Shamsundar Persaud, who is sitting in the court. At paragraph 10, he lists all of the movable property. It goes from A to U, several tractors, all things to do with rice farming, combines, all of that. That's not included in this assets of statement of liabilities that we had. The law requires that a report be made. That wasn't done. But if we go further, please, Your Honor, the application, which is why we asked that the application, the letter that was written to this court by my friend, to say that Dhavanie Persaud should be substituted in place of the person who was previously the representative, and we consented to that happening. In that email with the letters of administration, Your Honor, Dhavanie Persaud swears an affidavit that she doesn't know where to find the two boys. Now, if we had a trial, Your Honor, we could have told the court, she claims to be a social media influencer. She's a friend on Facebook with these two boys, listed as her brother, and she can't find them. These were the things that happened. How did she get to be the sole person to do anything about the estate to the exclusion with them?
Mr. Dachidin, let's go back to the order of Chief Justice George.
Yes.
How is that order is basically undoing the order of Justice Satyanand? Yes?
Well,
In part, at least. Let's just start there.
Your Honor, we could take that, yes.
Okay, good. What I'm trying to understand is, in terms of the order the Chief Justice made, are there parts of it that foreclose arguments that you would have liked to have made through maybe declarations, or prejudice you in litigating this matter fully?
Well, Your Honor, the order says, and I read what he says, an order setting aside, this is at page 599, an order setting aside the judgment, joining the second defendant as a respondent in that action. He's already there, but okay, I presume what you're doing is he's not there as representative of the two boys. He's now there in his own right, and giving such directions for the conduct. But the claimant is not there. So this action was brought by Mr. Satyanand Persaud against the estate, which was represented by the two boys, and their power of attorney was the second defendant. So presumably, what that does is it puts him there personally. So fair enough. But where is the claimant? Where is the respondents in these? They don't want to be in the proceedings? So Your Honor, the challenge, the big challenge of it all, Your Honor,
That will correct it. If all the parties were brought before the court to have a fair opportunity to interrogate the claim for the 400,000 US on whether we call it pro note contract, whatever. If all the parties, all the relevant parties in all the different capacities were brought before the court with a fair opportunity to litigate that, would that meet the justice of where we need to go? How would you answer that?
Your Honor, I would be required to that because...
You would be open to that?
Of course, Your Honor. But Your Honor, what I say is that's what this action was before Justice George. It was to say you breached all these fiduciary duties, and this claim you have of $4,000, pardon my way of saying, is a con. And but why didn't you name the two boys? They're the ones who gave the instructions to consent. If you're going to do it, then they would have...
Can that be cured? Can that be cured by agreement?
Adding them to the proceedings.
By agreement between you all, can that be cured, or however? In other words, look, there's a dispute about the estate and $400,000. Agreed? There are complaints.
Yeah, Your Honor, anything.
Is there a way in which we can circumvent this, get the parties who are all interested in litigating this in the proceedings to litigate? I think the entry point for dispute is this $400,000 claim. Correct? Whether it's legitimate or not legitimate, and how it impacts the estate or doesn't. Well,
I agree with you, Your Honor.
can we get these parties before the court and let us have a fair and full hearing on that?
Mr. D'Artagnan, you have 5 minutes.
Yes, Your Honor, if I may also indicate, Your Honor, much is said about what transpired in the Court of Appeal. We have no reasons as to what happened. And I say this with the greatest of respect, Your Honor. It is very difficult when a court is, in fact, on you about withdrawing proceedings to get to say what you're trying to say. What I was trying to say, very simply, was the opportunity to amend. If we read the transcript as a whole, you could see that that is being dismissive. Filing the application stating, and in fact what is finally pointed out in this court about what the court came as their ruling, made no consideration of merit. It was simply, you are out of time, we do not want to hear you, and that is the end. And respectfully, Your Honor, that can't be right. It would be great if I could take my notes that I have made and presented to the court. But the court has a transcripting system. Your Honor, if only to look how preposterous it is. It says that the proceedings were finished at 8:27 a.m. I mean, these are things that I don't want to complain about. It's part of a judicial system of which I am a part. But it wasn't at 8:27 a.m. that we were finished. But these things are still what the transcriber, all of what is said is not captured. But then we sit and we examine every word and everything as if it is accurate as a transcript. And I know that's all we have. I accept that. But the Court of Appeal order simply says it is struck out. We have no reasons. But then all that it is I didn't do things. I wish I could use my notes. I really do. But again, Your Honor, if we go back to the basic premise that Your Honor has raised, the proceedings that are before or that were filed before Justice George, if they are to proceed to trial, and my friend would consent to the two boys, they are at the stage where they would be witnesses. They may be better off being parties to those proceedings and joined in the exact proceeding about whether the fiduciary duties are breached. And if at a hearing, a judge listens to the evidence and says, you have breached the fiduciary duties and you could not consent, then the judgment of Justice Harnanan falls. And that would be the end of that. But if you're not allowed an opportunity to present a trial, the fundamental pillar of the judicial system is the opportunity to be heard. And, Your Honor, I don't wish to belabor the point, but there were three things that I wanted to say. The decision, the Court of Appeal, the application that we filed to the Court of Appeal for leave to appeal starts at page 411 of the record. Your Honor, it goes all, if the court looks at the affidavit in support of the motion that is filed, Your Honor. The statement of claim is Exhibit A. I'm reading from page 424 of the record. B1 and B2 are the defenses that were filed. The submissions made before the Chief Justice. Then the action that was filed, 148 of 2022, is Exhibit C. Exhibit D is the decision. We go on, we narrate all of the things. We then put D, the High Court action filed to dispense. Then E, the other High Court action of the judgment, with all the exhibits. So when it is said that we did not place before the court the material when we made the application for leave to appeal, respectfully, that's simply not true. We put everything, and that is why, Your Honor, in this court, you would notice in the record you have, it appears repetitive, but we have tried to head it up so that you could see stage by stage, what did we give to the full court? What did we give to the Court of Appeal? And even what we gave to this court in the leave application. We did it that way, Your Honor, where we know it is repetitive. And that's why perhaps we have 1,000 pages in the record. But, Your Honor, it is still the only way for us to come to this court and say, this is what was before the Court of Appeal. So to say that the Court of Appeal considered in Your Honor, Justice Jamadar's position of stage 1 and stage 2, that they had no material for stage 2. They never considered stage 2, and they did not look at the affidavits, the exhibits to the affidavit, which was everything. So respectfully, Your Honor, the position of resolving all of the matters that exist and the position of consideration and the application of Order 1, Rule 8, in the Court of Appeal about the interests of justice, Your Honor, this court, in Somra and Watson and Finance, went through the whole thing about 1-8, and that's where the phrase of Wooding was made popular, that it's not a game. Litigation and justice is not a game about who pulls first. It is about determining matters on the merits. Now, in these proceedings, Your Honor, what Mr. Satyanand Persaud is seeking to do is he is seeking to be heard on the merits. If it is he has breached fiduciary duties and his brother has breached fiduciary duties and the two boys have breached fiduciary duties, then we will consent to the order before Justice Harnanan going. And that would be the effect. A court would be entitled to do that. But before you hear what they have to say, you've taken it all away and then shut them out.
And your response?
I apologize for doing so, Your Honor. But there is only one part that I wish to raise as a result of what the court is saying. As I understand it, respectfully, Your Honor, these proceedings, there were no appeals filed in those proceedings, the proceeding of the judgment before Justice Harnanan. There was no appeal, there was no application to be joined or for it to be reheard. What was done is a separate proceeding was filed, and as my friend mentioned in his submissions, and it's well known, that if you allege fraud, you can set aside a judgment that had been granted before of a court. So, Your Honor, if this court, these proceedings, prove that fraud, then that judgment will go. But respectfully, Your Honor, the best way to solve it all is to have the hearing and join the two boys so that they could have a hearing too. And they will say whether they consented or not. They will say, my friend said that there is no evidence of Shamsundar, but they acknowledged it while they were beneficiaries and people who were dealing with the estate. So they would have had authority. So, Your Honor, respectfully, we plead with the court that the resolution of it is to have all be given a hearing and determination of whatever their evidence is. And if indeed it is fraud, then Your Honor knows better than me what will be the end result. I thank you, Your Honor.
Thank you, sir. Thank you.
Thank you
Mr.
very
Barton.
much, Your Honor. I know we've kept you way past.
No. We enjoy hearing you. Thank you.
My pleasure, Your Honor.
And I'd also like to thank all counsel who have made appearances, made submissions. Mr. Jonas, was there something you wanted to say?
Yes, please. Before Your Honor's rise, I'm very sorry. I know this is unorthodox, but my friend did point out what I realize is a typographical error when he talks about making the second defendant a party to the action. It should have said claimant. It should have said the applicant, Dhavanie Persaud, making her the party. But I just wanted to point out that was a typographical error that escaped me.
I'm sure the recording will help us on that. Thank you very much, Mr. Jonas, and thank you, Mr. Datadin. Thank you, Ms. Ali. Thank you, counsel. And we should recognize the presence of Mr. Persaud, who is here. Yes, indeed, and thank you very much for being here with us. We appreciate when parties can come by and observe the proceedings, and we were very happy to have you, sir, and those with you. Thank you. Madam Registrar?